Mr. Wright. Morning, Ms. Corea.
Good morning, Commissioner.
Yes, Mr. Wright.
Good morning, Commissioner. Our witness today is Dorea T, Corea, who is the internal auditor. Before I go through a number of matters with Mrs. Corea, can I just, for the transcript, confirm that in terms of legal representation for participants, there are no legal representatives either in the hearing or attending remotely. Mrs. Corea, I hope that you can see and hear me. Can you confirm that, please?
I can.
And just to confirm for the record, before the Commissioner came in, you have confirmed that you are in a private space, there are no recording devices, and your mobile phone is switched off.
Correct.
That's right. Thank you. You've also confirmed that you would like to take the affirmation today.
Correct.
Do you have the words of the affirmation with you?
I do.
Could you read those words out now, please?
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you. First of all, thank you very much for attending to give evidence today. You are doing so remotely for good reason, and we don't need to go into the detail of that. There are some formalities that we need to go through. First of all, could I ask you to give the Commissioner your full name, please?
My full name is Dorea Teresa Maduro Corea.
And your professional address?
3rd floor, Ashley Ritter Building, Wickham, Ski 1.
I'll try and keep my questions short and simple. If you have any difficulty, however, in understanding a question, or you would like me to repeat or rephrase it, please do ask me. I believe you've received a number of bundles for today's hearings. Can you confirm you have the bundles with you?
I do have the bundles.
We don't need to look at any yet, but as we go through your evidence, I'll take you to various documents in the bundles. The last thing to remind you of is just to try and keep your voice up, please, and speak slowly. That way we can ensure that your answers are accurately and clearly recorded on today's transcript. Thank you. Can we start off with this question, please? Could you give the Commissioner an outline of your professional background before you were appointed as Director of the Internal Audit Department?
Okay, I joined the Ministry of Finance in 1995 as an Assistant Internal Auditor. As a new employee upon completing my tertiary education in marketing and finance from the University of the Virgin Islands. Since that time, I have been promoted through the ranks. 2001, becoming a Senior Internal Auditor. 2006, becoming a Deputy Director. And my last being confirmed to the post of Director of Internal Audit, effective July 1st, 2013. I had acted in that capacity in 2 previous occasions. Firstly, in 2007, and secondly, in 2012. Over my tenure, I have received extensive professional training in the disciplines of internal auditing profession, nationally, regionally, and internationally.
Thank you. The Internal Audit Department, as presently constituted, was established under Section 3 of the Internal Audit Act of 2011. But was it operating prior to 2011?
It was.
And I believe it was set up in 1991, is that right?
That is correct.
Before the 2011 Act, what was the statutory basis for the Internal Audit Department?
Well, the Internal internal audit started as a unit within the Ministry of Finance. It was established under the Financial Secretary, and it was instituted to provide assessments for departments within the government service, primarily the Ministry of Finance, on the processes that were completed for their public services. When it first was constituted, it primarily was reporting to the Financial Secretary, and as it evolved, an ad hoc audit committee was commissioned. That was commissioned comprising of all the permanent secretaries, including the Deputy Governor, the Accountant General, and the Auditor General. And that was the reporting functional body at that time.
Right.
That body functioned until 2002.
2002, did you say?
Correct.
If you take it to post the 2011 Act, what would you say the purpose of the Internal Audit Department is now?
Well, it facilitates the same intent. Only thing, because we evolved and we realized that the function is an independent function, it drove reason to create the Audit Act and the Audit Committee, which is the Internal Audit Advisory Committee.
The Section 4 of the Act, I know you don't have it with you, but can I just read out what Section 4 says in terms of the function of the Internal Audit Department? It's firstly to monitor the systems of internal control of a public authority using generally accepted internal audit standards. Second, to evaluate and report on whether the systems of internal control of a public authority are adequate and efficient to ensure that, one, government assets are adequately safeguarded, used only for identified purposes or other purposes approved by law, and used economically and efficiently. Two, risks may be identified and managed. Three, the financial management control information of a public authority is accurate and reliable. Four, the operations of a public authority are compliant with policies, procedures, and the law. The next function that the Section 4 of the 2011 Act gives the Internal Audit Department is to review operations and programs of a public authority to ascertain whether the results are consistent with the objectives of the operations and programs of the government. The next function is to report and make recommendations to the head of a public authority and the committee regarding any irregularity or significant control weakness occurring within that public authority. Then it's to design plans to be approved by the committee for the development and maintenance of efficient internal audits of public authorities, and to design plans to be approved by the committee for the improvement of systems of internal control of public authorities. And finally, it's to prepare audit acts in accordance with the 2011 statute. So it's quite a wide-ranging role, isn't it?
It is.
And do you see, or would you agree that an effective internal audit department is a means by which government can enhance good governance, transparency, and accountability?
I do.
It's a way, isn't it, of ensuring that government operations are efficient and effective.
It is.
And that public bodies manage risks and their budgets sensibly.
Correct.
Now, you've mentioned, and I've just mentioned when I read out parts of Section 4 to you, the Internal Audit Advisory Committee.
All right.
Is it right that under the Act, that's the committee to which the Internal Audit Department reports?
It is.
And it's created by Section 6 of the Internal Audit Act 2011. And Section 7 gives it several functions. Firstly, that it has to establish standards and procedures for the effective control of internal audits by the department. Secondly, it has to advise the department in relation to the performance of its function under the 2011 Act. Third, it has to advise the department on policies and procedures for the development, maintenance, and improvement of systems of internal control for public authorities. And then it has to, fourth, advise the department each financial year on an audit program for implementation, which shall include which public authorities will be audited, how they will be audited, any government program or policies relevant to the public authorities to be audited, and any internal audit control deficiencies relating to the public authorities that are known to the department. And the last function that the committee has is to review the audit reports forwarded to it by the director. So would it be fair to say that part of the function of this committee is to guide the work that is done each financial year by your department?
Absolutely so.
Now, under Section 8 of the Act, Section 8 says that the committee is appointed by the Cabinet upon the recommendation of the minister. Now, where it refers to the minister, is that the Minister for Finance?
Yes, it is the Minister of Finance.
Now, as I understand it, the committee will have 5 members to it. So it's no longer a committee of permanent secretaries, but the 5 members have 2 ex officio members. And one of them is yourself as director of the Internal Audit Department, and the other is either the financial secretary or the deputy financial secretary. That's right, isn't it?
That is correct.
And so the other 3 members that are appointed, those are the 3 people that the Cabinet has to approve and appoint. Is that right?
That is correct, sir.
And as I understand it, and this is in the Act, that firstly, it has to be a chairperson who's a person of good standing in the accounting or auditing profession. Then the second person has to be a senior public officer. And the third is a member who is not a public officer and who's determined by the minister. So that's someone from the private sector.
Correct.
Now, you have, Mrs. Corea, in the past had a committee in existence, but is it right that the last committee ceased its work on the 31st of December 2016?
Yes, that's when the appointments were expired.
And that was the appointments of those people who'd been appointed to it by Cabinet?
Correct.
That committee, which ended its work in December 2015, when had it been appointed?
2016, not 2015. It was appointed in 2014.
I spoke over you. Could you give us the date again, please?
It was appointed in 2014 and the appointments expired in 2016.
Can you remember which date in 2014 it was appointed?
The appointments, if I can recall, was January 1st.
So it was in existence for a 2-year period. During that 2-year period, how often did the committee meet?
According to law, it was required to meet every quarter. Unfortunately, that was not the case.
Who's responsible for organizing the meetings?
The chairman is.
Chairman. And who was the chairman of that committee?
At that time, it was Miss Italia Penn.
That's it, Italio Penn, yes?
Yes.
Thank you. Well, you've confirmed that its term expired on the 31st of December 2016. Before that date, when was the last time that the committee had met?
According to my records, in August of 2015.
Obviously, the committee, as it's now constituted, was established under the 2011 Act. Between 2011 and 2014, was there a committee in place?
No, there was not.
Now, we understand from the issue of the BVI Gazette published on Thursday, the 24th of June, 2021, that on the 21st of June, 2021, Cabinet appointed 3 members of the committee, the Internal Audit Advisory Committee. Before it was published, or let me put it this way, have you been informed directly of those appointments?
I have been.
How were you informed?
I was informed by email and by correspondence coming to the office.
And can you confirm that the 3 new members of the committee are firstly Miss Italia Penn, who's going to be the chairperson? Is that right?
Correct.
And then Mrs. C. Jovita Scatcliffe and Mr. Terence Gums.
Correct, sir.
Do you know where, obviously, Miss Italia Penn was the previous chair of the 2016 committee. Do you know whether Mrs. Scatcliffe and Mr. Gums have previously been members of the committee?
They have not.
Since the 24th of June, 2021, has the new chair of the new committee been in touch with you?
Not to date, sir.
Your voice slightly dropped. Did you say not to date?
Not to date, correct.
Now, what follows from your evidence, Mrs. Corea, is that between the 31st of December 2016 and at least 21st of June 2021, there has not been a committee in place. What impact has that had on the work of the Internal Audit Department?
Because the work of the Internal Audit Department is supported and driven by the Internal Audit Advisory Committee, there was no functional reporting responsibility as far as the Internal Audit Department was concerned. So the department was left without a functional reporting body and in turn reported to the Ministry of Finance.
During that time, which is over, I suppose, nearly 4.5 years, did your department make efforts to try and re-establish the Internal Audit Advisory Committee?
We have on several occasions.
And I mean, who were you able to write to try and get it re-established?
Well, because we administratively report to the Ministry of Finance, we have been writing to the Financial Secretary.
And realistically, is writing to the Financial Secretary seeking the re-establishment of the committee the only step that's open to you as Director of the Internal Audit Department?
Well, directly, currently, yes.
And did you put forward any names of people who might be suitable for the committee?
They had asked us and we did, yes.
And did you raise the need for the committee on more than one occasion?
Yes, sir, I did.
Can you remember the most recent occasion that you wrote to the Financial Secretary?
February 3rd, 2021.
Now, have you had any explanation for why it took so long to re-establish the committee?
No, I have not.
And even if we take, I mean, obviously, as I've said, it stopped working on the 31st of December 2016. And although it's been re-established very recently, it has yet to meet. But even after your last contact, the last time you raised it, which was the 3rd of February 2021, have you had any kind of explanation of why it's still taken some months to appoint the 3 members of the committee?
No, no explanation was provided, sir.
Now, correct me if this is wrong, but when we look at the reports that you have provided to the Commissioner, which go back to 2009, there does appear to be a decline in the number of reports that your department has been able to produce in recent years. And so since 2016, you've produced reports. It's either 3 to 2 reports each year, whereas before that, for example, in 2015, you produced 7 reports. Is that decline linked to the fact that you did not have a committee to report to?
That can be one reason, but there are many others.
What other reasons were there?
Okay, you have the absence of a committee, yes, one. We've also have a decline in human resources, that's 2. In terms of responsiveness from department, which is a continuous mantra, it depends on what information we receive, we can actually have a report completed. And that's for 4 reasons.
Can I'll come back to some of those other reasons in a moment, but in terms, just to finish off on the committee, I mean, one function of that committee is to advise you as to what your audit program should be. Is that right?
Correct.
And what the committee can also do, and this is under section 14 of the Act, it can ask you to carry out an ad hoc investigation of a public authority, can't it?
It can.
Let's turn to your point about human resources. I think it's right, yourself and your staff are appointed by the governor.
That is correct.
As you said, you report functionally to the committee, but administratively to the Ministry of Finance.
That is correct.
So where does your budget come from, Mrs. Corea?
It is administered under the umbrella of the Ministry of Finance. Since we are a department under the ministry.
Do you have your own budget each year to allocate as you think necessary? How does it work?
We have the option to prepare a budget and submit it to the Ministry of Finance. But of course, like every other department's budget, we go through a process. And we also go to standing finance where the budgets are reviewed, and then it goes towards the process of having a passed budget. So there are different steps from the time we make a budget from our department and what actually is executed at the final remit.
And does it work like this, that you will start your financial year with an allocated budget, a paper budget, so to speak. But as you go through the year, if you want a particular resource, you have to apply for it. And there may be occasions when you're told there isn't the money for that resource.
That is true.
So even though you might think on paper there is money for that resource, once it goes through the process, you might be told actually it can't be funded.
That is true.
Now you've spoken about human resources. Do you consider, as director of the Internal Audit Department, that you have the resources to carry out your work effectively?
We have the resources in terms of post, but in terms of bodies, no. And there's a reason why I say that. Currently, we have 6 technical officers assigned to our department. And of those 6, we currently only have 2 bodies sitting in office. We have 1 officer on secondment, and we also have 2 officers on reassignment. We have 1 who has retired, and then we have another assistant position that's vacant.
And in terms of your sort of ideal capacity, in terms of persons in the office, what's your optimum size of the office that you need?
Well, in terms of need, it depends on terms of activity. So if we have a fully fledged audit plan and activity in terms of responsiveness from departments, it probably be more than the officers that we have. But because we don't have the activity which is driven by the committee, then I wouldn't say per se that we need additional staff. But once we engineer to have the added activity in gear, I'm sure we will need more staff based on the size of the public service.
So it's slightly chicken and egg, isn't it? Because if the committee gives you a very ambitious audit plan, you may not have enough personnel to fulfill that plan.
That is true.
But until the committee gives you a plan, you won't know what resources you need.
That is correct.
But the committee may, if the committee and if the committee sort of adapts its plans to fit in with the resources that you do have, that may mean that there are some important audits that are not undertaken.
That can possibly be the case, sir.
Can I just ask you about some general questions about the process of producing reports and how you produce reports? So you are under Section 4 directed to prepare audit reports. So that's one type of report that you will prepare, isn't it?
Correct.
And you can also do follow-up audits. Is that right?
That is true.
And as we've said, the committee could ask you to do an ad hoc report. And under Section 16 of the Act, the Internal Audit Department will also investigate if there's a report or an allegation of irregularity or fraud. Is that right?
That is true.
Now, in the Act, under Section 12, what section, that's your general powers as an auditor. What Section 12 says is that in relation to a public authority which is being audited, the director or an auditor may, during the course of an internal audit, A, access any government asset or property belonging to a public authority which is in the possession of or under the control of a public officer or an employee of the public authority. B, enter and inspect any premises of the public authority. C, search or inspect any document, record, or information of the public authority and obtain extracts or copies of the documents, record, or information. And D, request from any public officer or employee of the public authority any information or document, including electronic data, which is relevant for purposes of an internal audit. So does that translate to that as the internal auditors, you have a statutory right to see whatever documents you consider necessary to do your work?
Correct.
Obviously, as we've established, when you go into a public authority to do an audit, you will produce a report at the end of that. And you will usually, won't you, make recommendations in that report?
We would.
Do you give the public authority an opportunity to respond to the report before you finalize it?
Every time, yes, we do.
And do you describe that as a management response?
That is correct, sir.
And once you get that response, are there occasions when you might respond to the response?
That is correct, sir.
And then it's finalized. Once it's in final form, responses have been received, and everything's been dealt with. Where does that report go after that?
Okay, once the report is finalized, it goes, of course, to the client, which is the accounting officer or the CEO, depending on what type of agency it is. It goes to the Ministry of Finance, the Minister who would report it to the Minister of Finance. It also goes to the Deputy Governor's Office and the Auditor General.
Presumably it also goes to the committee if it exists.
Correct. Sorry about that. It goes to the committee first. Sorry.
But essentially, your report will be provided to everyone who might be affected by its recommendations.
That is correct, sir.
What happens if you don't get a response to your draft report?
It remains a draft report. We just finalize it as a draft report.
And does it go to anyone else?
No, it doesn't. And that's where the committee would come in to play that role in effecting our responsiveness. So the chairman would then get involved in the process to ensure that the public authority responds to the report.
Going back to the 2014-2016 committee, how, in your experience, how effective was that committee in persuading public authorities to respond to your drafts?
It played a role, and based on the activity that we had, because it was so minimal, the role was not driven, in my opinion, in the way it should go. And there were times when we had situations where the chairman did get involved to make sure that the authority responded, and it still was restricted. And in that process, the matter went to the minister, and it was addressed at that point.
Since 2016, you haven't had a committee to assist in that process.
No, we haven't.
And have you noticed any trends at all in the willingness of public authorities to respond to draft reports since 2016?
Well, based on my experience, it depends on the authority that's being audited, and sometimes the activity that was completed and what the results were. But we have been receiving responses in some areas while others were restricted.
Because if you know that there's no committee, it could have the effect of just bringing your audit to a halt if the public authority just doesn't respond to your report.
That can be the case.
Because your report just ends up staying in draft, doesn't it?
It does.
You will also, and I think we use the section 16 examples of irregularity and fraud. You will, as the internal audit department, also investigate specific issues, won't you?
Yes, we have.
Now, part of your function is to make recommendations. You've got to do that under the Act. Looking over the time, particularly the time since the committee ceased to exist, Have you noticed any general trends in the responsiveness of public authorities to recommendations?
Well, I wouldn't say it would be dependent on the committee being appointed or not, because there have been times when we have had the committee and there was still non-response. However, when we do make recommendations, the authority have the option to agree or disagree with the recommendations that we make. However, they would have to provide substantial reason as to why.
Is that reason as to why they disagree?
Correct. Because if I must add, once you agree, you're supposed to also identify an action plan as to how you intend to implement the recommendations and what time frame you're giving the auditors.
Do you think there are, oh, I'm going to say that again. In your experience, are there particular factors that you can identify that make it more likely that a public authority will respond positively to a recommendation?
Say that again.
Taking your experience, are there any general factors that you can identify that make it more likely that a public authority will agree to a recommendation?
If it's in their favor, yes, they would respond.
Now, you do follow-up audits. Would you do that in every case where you've made recommendations?
We should, because it's part of the audit cycle. But again, because of minimum human resources, we are unable to do every follow-up.
And in your follow-up audit, can you make additional recommendations?
Yes, we should.
But ultimately, I mean, if a public authority comes up with an action plan, is it the responsibility of the internal audit department to make sure that they implement the action plan?
No.
So all you can do is monitor the extent to which they accept or reject the recommendations, make follow-up recommendations. But after that, is there anything else that you can do as the internal audit department?
Well, if the internal audit department makes recommendations, it means that there is something that needs fixing or something that can be improved. So if the public authority does not respond, it means to us that they're accepting a certain level of risk because it would be to improve their effectiveness and efficiency. When they don't respond or when they don't implement recommendations, depending on the level of risk exposure, the department will then, of course, when the committee was available, beckon on the committee to go further with the recommendations to probably the ministers or to the deputy governor, whomever it would affect directly and adversely. But if in the absence of the committee, we usually don't have any resolve, we would usually utilize the financial secretary to assist us in making sure that those recommendations are implemented, especially if it have a financial implication involved.
In terms of your budget, you've spoken about human resources and the impact of that. But in terms of your budget, do you think your budget is sufficient? I'm sure everyone would always want more money, but if this new internal audit advisory committee were to come up with an ambitious audit plan, would you have the budget to be able to deliver that plan?
No, we would not.
What on your current capacity in terms of human resources and in terms of budget, How many audit reports can your department feasibly do in one financial year?
Comfortably and effectively, I would say, with all staff in place, all competent staff in place, I would say at least minimum 5.
5. If we look at sort of 2019, you did I think, three reports in 2019. So are you very much dependent on all your staff being available?
Yes, we are.
And is it the case that the minute you lose 1 or 2, either on secondment or retirement or whatever, your ability to deliver is compromised?
Drastically, sir.
Give me a moment, please. I'd like, if I may, just to take you to some of the reports. Do you have the first bundle with you? I think it's called Part 1.
I do.
If you go to page 851, open brackets 1, close brackets, please.
Say that number again, sir.
Page 851, and then it's open brackets 1, close brackets 1. It was, I think, an additional insert.
I'm not seeing that page, sir. Let me see.
Could I ask you just to rise briefly, and I will try and sort that out with Mrs. Corea. I think probably it's a good time anyway to give the stenographer a break because we're moving on to a new topic.
Certainly. 5 minutes, Mr. Wright.
Mrs. Corea, the Commissioner is going to rise, and we'll try and make sure that you have a copy of the report that I want to go through with you. All right?
Okay.
Good. Thank you. Good. Thank you, Mr. Wright. Have we sorted that out?
Yes, we have. Mrs. Corea has confirmed that she has the report that I wanted to take her to. So thank you very much, Commissioner, for that time. Mrs. Corea, the report that I wanted to take you to is at page 851, open brackets 1, close brackets. And that's a report of the Internal Audit Department from June 2012 on the Immigration Board Belonger application process. Can I confirm that you have that?
Yes, sir, I do.
If you go to page 4 in that, or internal page 3, for the transcript, it's and your note, Commissioner, it's page 851, open brackets 4, close brackets.
Yes.
Correct.
There's an introduction there, which if I can read that to you, please, Mrs. Corea. It says at 2.1, belonger status is a legal classification normally associated with British territories. It refers to people who have close ties to a specific territory, normally by birth and or ancestry. The requirements for belonger status and the rights that it confers vary from territory to territory. In the British Virgin Islands, the Department of Immigration, through the Board of Immigration, facilitates the process of belongership under the rights of marriage and residency. Under this arm, belonger status is granted under the Immigration and Passport Ordinance, Cap 130, Section 16. Additionally, the definition of qualifications for belonger status is in the British Virgin Islands is contained in Section 2.2 of the Constitution and includes 9 different methods by which a person may be regarded as belonger. In 2004, Government of the Virgin Islands outlined the details of a new immigration policy framework in an effort to add further structure and clarity to the rules surrounding application for residency and belonger status, and formally committed itself to bestowing status to no more than 5 persons a year for those persons applying for status on the basis of having residing in the territory for 20 years. Over the years, numerous complaints have surfaced referring to the process as a lengthy one and the lack of information as to the status of a person's application within the process. As a result of the implications of this service that government provides, along with its implications on other government programs, the need to review the process and the functioning of the board forms the basis of this exercise. So that explains how the Internal Audit Department came to carry out this exercise. If you go to the next page, 851, open brackets, 5, close brackets, you set out there, or the department sets out, the scope of the audit. And so we see that at 5.1, it records the audit focused on the belonger status issued from 2009 to 2011. That the audit had 3 objectives. The first is at paragraph 6.1, to give assurance that the system of processing belonger status applications is transparent and equitable. At 6.2, to give assurance that controls are adequate to safeguard the system from abusive practices. And at 6.3, to give assurance that the Immigration Board is functioning effectively and in accordance to statutory or policy requirements. The report then goes on under audit criteria to set out as follows. In planning and conducting the audit exercise, relevant legislations, policies and procedures were reviewed. Documentary evidence in support of our findings and conclusion were derived from department's report and files. A sample examination of persons to whom belonger status was granted for the scope years was also conducted, and the results of these testing form part of our audit findings. Interviews were conducted with pertinent staff from the Department of Immigration. In addition, the chairman of the Board of Immigration was also interviewed to gain an understanding of the board's operations and the process that governs the awarding of belonger status. Just to pause there, Mrs. Corea, in terms of setting the sort of ambit of a audit, Is this typical of the approach that the department will adopt?
Every time.
Policies and procedures, you will interview people, you will perhaps take a sample of applications, for example, or samples of persons to see how the process works. Is that right?
Yes, that is standard internal auditing processes, yes.
Now, you said standard audit processing, and I should have asked you this before, but could you just explain to the Commissioner what standards does the Internal Audit Department operate by?
Currently, we're guided by the IPPF, which is the International Professional Practices Framework from the IIA, which is the Institute for Internal Auditors. That's where we get our guidance from in terms of internal auditing function.
Now, if you go to the next page, paragraph 8.1, there is a heading called Audit Limitations. Is it also usual practice to set out any limitations that they may have been on the audit that you have to carry out?
That is correct, sir.
And for example, that might be if you didn't have access for whatever reason to documents that you wanted.
That is correct, sir.
Now, in this case, you've recorded this. This review was limited to reviewing the process as far as the recommendation phase, and we'll come back to what you mean by that shortly, as auditors were not allowed access to the cabinet papers approving individuals for belonger status as they were deemed confidential. The lack of information and documentation required to thoroughly assess the process limited the team's ability to adequately assess the entire process, especially at the approval stage or cabinet level. So take it from that the internal audit team were not allowed to see cabinet papers. Is that a common occurrence?
In most instances, yes.
And is that particularly so in relation to cabinet material?
That is correct.
Now, we looked at a little earlier your powers under Section 12. Do you consider that, on your understanding what Section 12 allows you to do as an internal auditor, you could have access to cabinet papers if you wanted?
That is correct.
And is your understanding of Section 12 that there's no basis on which someone can refuse to give you the material that you want as an internal auditor, is there?
That is correct, sir.
And it's right, isn't it, also that your reports are not made public, are they?
No, they're not.
They'll go to, as you explained earlier, relevant individuals, the public authority being audited, the relevant minister, and they go to the committee.
Correct, sir.
Thank you. Could we look on the same page as under the headings at facts and findings and just go through what the internal audit revealed in relation to your three objectives? To remind you, your objective one was to give assurance that the system of processing belonger status application is transparent and equitable. And you divided in the report the process into three phases. The first one, and tell me if I've misunderstood this, is an application process where an application is submitted to the Department of Immigration. The second phase is where there has been what you call a consideration and recommendation phase, where the application is reviewed and the board then makes a recommendation. And that recommendation is a recommendation made to cabinet, isn't it?
That is correct, sir.
And the final third phase is an approval or denial phase, where cabinet either approves or denies the recommendation. Now,
that is correct, sir.
Thank you. If you go, please, to using your internal numbering, if that's easier, Mrs. Corea, if you go to it's the appendices which are not numbered, so I'll have to use the numbering that the inquiry has given the document. 851 open brackets 27 close brackets. Let me know when you have that page.
'27, you said, sir?
27, yes.
I have it.
Appendix 3. This is an appendix to the report, and you've set out, the Internal Audit Department, that is, has set out the application process for belonger status in a little bit more detail, and you say the process is as follows. I'm going to summarize this, but if you think I'm missing out relevant details, please do tell me, Mrs. Corea. The first is that an application is collected, completed, and then submitted to the status unit of the Immigration Department. The second stage is that the submitted application is then reviewed by the unit for completeness. At the third stage, once that review is completed, the applicant gets an acknowledgement letter from the status unit. But if on review the application is found to be incomplete, the status unit would contact the applicant, indicating what further information was required. At fourth stage, once the completed applications are placed, they're then placed in a queue for consideration by the Board of Immigration. And you explain that the queues are placed, the applications are placed in queue based on qualifying year and whether the status is being granted is based on marriage or residency status. And in then considering applicants to be interviewed, the board uses two principles. The first is a policy decision, whereby what is now Cabinet approved a policy that no more than 25 applicants per year for those applicants who possess a certificate of residency will be considered for belonger status. They must be in possession of a certificate of residency for at least 1 year and be residing continuously in the territory. And the second is in relation for those seeking belonger status by marriage. There's no quota for those, but each applicant has to satisfy a 5-year residency period in the territory with his or her spouse as husband and wife to be considered. The fifth part of the process is that the board then decides which applicants are to be interviewed, and the applications are selected based on the date of application and the qualifying year. The applicants are then interviewed, and during the interview, what's called a cultural questionnaire is administered. The applications and interview summaries are then prepared along with the score from the cultural questionnaire, prepared by a status unit officer and submitted to the board for consideration. And the board, when it considers the applications, will use a point system. And so the application has to get 50% of points from those areas which are applicable to the applicant. That gets you a recommendation. If you're below 50%, if I've understood it correctly, the application will not be recommended to Cabinet. Is that right?
That is correct.
And then minutes are prepared for the board meeting. They're signed by the chairman, and that is all then sent to the Premier's office to prepare a paper for Cabinet's consideration. And what Cabinet's job is to do under this process is to review the recommendation and either approve or reject it. Is that right?
That is correct.
And for those persons who have an application and a recommendation approved by Cabinet, that then goes back to the Department of Immigration for preparation of certificates and a ceremony to confer the status. That's hopefully summary. That's the process that the audit of 2012 identified as the route through when you're applying for belonger status. If we go back to page 5, please, in the document. That's internal page numbering. And if I take you to paragraph 9.2, what the audit report says there is that in an effort to improve decision-making and bring transparency and equitability to the process, the board had implemented various tools, and you point to the use of a point system, an interview process, and a cultural questionnaire. And it's right, isn't it, that in the audit, these were tools that the department, your department, said was yielding desired results, and you commended the board for taking that action?
Yes, we did.
So it seems to be, to the auditors, a fair and equitable process had been put in place from the time that the application is made to the time that the board makes the recommendation to cabinet. Is that right?
That is correct, sir.
If I take you, however, to paragraph 9.5, the audit says this: during the course of the audit team was made aware that there were numerous applications that were awarded outside the standard framework established by law and policy. It was revealed that Cabinet approved some 224 persons who were not considered by the board and for whom no recommendation was submitted. In some instances, persons did not even make a formal application for the status before it was approved. However, these individuals have not yet received status, as the manner in which the status was awarded is questionable and could be deemed illegal. Advice is being sought from the Attorney General's chambers to deal with these applications. So I appreciate that it's some time ago, but can you confirm whether this is what happened? That at this stage, the audit identified additional individuals that were being put before Cabinet for approval without having gone through the process?
Well,
That is correct, sir.
Yes, I mean, I think what 9.5 suggests is that you said, Mr. Rowett, put before Cabinet, that it somehow Cabinet approved these people without them going through the process.
Yes. Is that right, or internal auditor, that the Cabinet approved 224 people without them going through the process?
Outside of the process, yes.
And so in terms of the sequence that we had discussed, since the Premier's office is the ministry responsible for putting these before Cabinet, that's where that seems a likely point where those 224 individuals would have been introduced into the process.
Correct.
Sorry, I spoke over you. I didn't catch your answer.
Correct, yes.
What the audit says, and it's at the next page, at 9.6, is that while we agree that Cabinet is the ultimate deciding body in granting Pelonga status, the awarding of this status in the manner it creates an inequitable situation for the 334 persons whose applications are still being to be considered and recommended by the board. Additionally, it removes any level of transparency within the process, as there is no clear justification to indicate the merit of the decision. And from the purposes of the audit, you could not take this further, presumably, because you were not allowed access to Cabinet papers.
That is correct, sir.
If we look on this page now at Objective 2, which was to give assurance that controls are adequate to safeguard the system from abusive practices, You make the point, and I'll try and summarize this at 9.8. And when I say you, Mrs. Corea, I'm speaking of the department and of the report. But the report says that makes the point at 9.8 that there was just one officer, a senior executive officer in the immigration department, dealing with the administrative functions relating to the process. And what the concern that is raised by the audit report is that the magnitude of work required for the efficient and effective flow of the process is greater than the human resources assigned to the function. So it needed more people to make sure the process was efficient. Is that right?
That is correct, sir.
If you look at 9.9, and this is part of the audit investigation, what the report says is a listing of persons receiving belonger status for scope years 2009 to 2011 was requested and reviewed in an effort to determine whether applicants receive status based on established law and policy. The audit found that of the 77 persons to whom status was granted, only 45 of those persons were awarded status within the framework of the law. Of the remaining 29, although an application was submitted to the board, they did not go through the established process. And you say then, you refer to a table in the report, but that you continue, the granting of these status raises some concerns as to adequacy of the controls within the process. Because the point is then made that bearing in mind that the 29 individuals who were not recommended by the board for belonger status did not go through the formal process, this would then render the basis on which a decision was made to grant them status questionable and possibly unlawful. Furthermore, no due diligence was conducted, and therefore it is possible that the basic requirements for awarding of status were not met. You then go on to say if due diligence was conducted, then Cabinet would have been aware that the 3 persons to whom status was awarded already possess status and should not have been awarded again. This would not have resulted in a duplication of status being granted to persons. So again, does this just go to the point that there were some people who were being granted status even before the board had considered their applications and made a recommendation?
I wouldn't say that the board did not see the application and make a recommendation. What it says is that there were 3 persons who were granted status prior to the list that was being presented at the time.
So they already had belonger status?
They already had status, correct.
So that if any due diligence had been done, that would have been spotted? Correct,
sir.
Yes, thank you. And just looking at table 1, which is in paragraph 9.9.2, that shows the awards of belonger status for 3 years, 2009, 2010, 2011. And in the first 2 years, the persons approved for belonger status were the same as those recommended by the Immigration Board. The disparity appears just to be in the year 2011, when there were 52 persons approved for belonger status. 20 of those had been recommended by the board. 29 had not been recommended by the board, but had been awarded status by Cabinet. And there are also the 3 who possess belonger status already. So it's just in that year that there was this disparity.
Correct, Commissioner.
Thank you very much.
And if we look at 9.10, the report highlights a difference between the policy and the law. You found that the policy guidelines issued by Cabinet meant that applicants were not considered by the board because they didn't meet the 25-year requirement as stated in the policy, but that in fact, as a matter of in law, they were entitled to apply for that status after 10 years. Because under the Immigration Act, they could apply for belonger status after 10 years, but Cabinet's policy had been not to give it unless they had until after 25 years. Is that right?
That is correct, sir.
And if we look at table 2 on the next page, which is headed belonger status approved by Cabinet outside the framework of the law, again, the audit took 3 years, 2009, 2010, 2011. And what it shows, or it revealed, was that persons who were awarded status outside the framework of the law, none in 2009, none in 2010, but 224 in 2011. Is that right?
That is right, sir.
And of those, what the table also says is that, again, persons who applied before status was approved, but board did not recommend, none in the 2 years, 2009, 2010, but 32 in 2011. And so those were people who still had their application pending and hadn't been recommended, but then got status.
That is correct.
And then one person applied for status after status had been awarded, and that was in 2011 alone. There were persons who had not applied, 190 of them who got status in 2011, and then one person already possessed status.
That is correct, sir.
And just for the transcript, although of those categories that I've just listed, the numbers for 2009 are 0, the numbers of 2010 are 0. This was all happening in 2011, is that right?
That is right, sir.
What's also said at 9.12, it was revealed that the names of the individuals on this second listing, that's the table I've looked at a moment ago, were added at the Cabinet level based on personal representations by members. Therefore, these names would not appear on the Cabinet paper presented by the Premier's office from the board's recommendations. This means that the basic legal requirements of an application being made and consideration by the board were not met. The only basis on which one can judge status that were awarded in this manner is that the individuals made personal representation to a member and approval came as a result. The awarding of status in this manner further raises a number of control issues as to the authority of Cabinet members in operating contrary to established laws and policy. This is even more alarming, especially as the issue is at the highest level of approval within the process. So where you're referring to members there at 9.12, where the report refers to members, is that members of Cabinet?
Rightfully so.
And so going back to the process, once the board has made recommendations, it submits those to the Premier's office, which then prepares a paper for Cabinet. And that paper then goes to Cabinet. But these names were being added after that stage. They were coming in at Cabinet level itself. Is that right?
That is correct, sir.
If you go, please, to our page 14. So The internal audit department made 9 recommendations. I want to come back to those shortly. But what I will ask you to do is, if you turn to the very last document in the paper, page 16. The internal audit department made the following conclusion. We applaud the efforts of the board in implementing tools to bring transparency, equity, and to assist with the decision-making process on belonger status applications. The board's role within the process creates a level of control where the information on applications are reviewed, verified, and validated. It forms a central basis on which Cabinet can make a sound and accurate decision on an application. The law, policy, and formal processes and procedures create a structured environment in which decisions can be made and transparency and equity can be established. However, the law, the policy, and the procedures should mirror each other to avoid any confusion or misinterpretations in facilitating the process. When transparency and equity is removed from any process, it creates doubt in the eyes of the public as to the integrity of the systems and processes. The report then goes on to say this: we have concluded that in the awarding of belonger status, the board has executed its role in an admirable manner. However, we have also concluded that the process has been significantly compromised by Cabinet's gross abuse of its authority. The process used by members of Cabinet lacked both transparency and objectivity. Cabinet, which in our estimation is a policy-setting body, unnecessarily circumvented the law, policy, and process, and failed to ensure that the process they used was transparent, objective, and that their decisions were based on sound advice and accurate information. We're not questioning Cabinet's authority to approve status, as it is their privilege to approve or disapprove an application. However, we are concerned that when this is done contrary to the law and policy, and there is no sound basis or reason given for the decisions made, it erodes the integrity of the process. If Cabinet, as a matter of their right, disregards a process after the process is established in law and policy, then the fundamental principle of the transparency and equity within the process is severely undermined, if not destroyed. In addition, we found that Cabinet, by taking it upon themselves to approve persons who were not vetted by the board or did not even submit an application, removed from the board the ability to scrutinize the applicants, thereby rendering the board's role null and void. Furthermore, it is our opinion that the practice whereby Cabinet approves status for individuals who are not vetted by the established process creates an environment in which favoritism, cronyism, and corruption can flourish. The Internal Audit Department did a follow-up report to this in 2014. I'm going to take you to that follow-up report in a moment. But can I ask you this, please, Mrs. Corea? What was, if anything, can you remember was the response to the conclusions of this audit report?
I can't recall entirely, but I do know that based on the findings and the recommendations that we made, they were in agreement with the what we had found, and it was factual. It was our factual findings. The recommendations that we made were practical, and we had expected that they would make all attempts to incorporate them in their processes. As you would realize, we did commend them for the work that they were doing as a board, because they did implement certain practices that actually added value to the process. So we did commend them for that. So they were making attempts to make sure that the process was transparent and equitable to all that applied.
We look at the follow-up audit report. It's in the second bundle that was provided to you. And it's at page 1735. Do you have the page, Mrs. Corea?
I have it.
Thank you. So this is now a report dated January 2014 and headed Follow-up Audit Review, Department of Immigration, Belonger Application Status. If we go to the introduction, which is 1737. The first report that we've just gone through made 9 recommendations, and what your report notes in January 2014 was that the majority of the recommendations had not been implemented. So of the 9, none were fully implemented and only 2 had been partially implemented. Is that right?
That is correct, sir.
In terms of, I mean, we're now almost, I suppose it's 18 months after the internal audit report of June 2012. On your 2014 report, there doesn't seem to have been much progress. Was it a surprise to the internal audit department that there hadn't been implementation of the recommendations?
It certainly was, because they agreed to the recommendation being made, and they did provide information to actually implement those recommendations.
Take as an example, and Commissioner, unless you require me to, I won't read all of these recommendations into the record. But if we just take recommendation number 1 as an example, this was a recommendation that amendments be made to the Act to make it more reflective of issues and realities that exist in the global arena as it relates to immigration and the awarding of status. And this goes to the point that the audit had picked up, that whilst the policy was 25 years, the Act was 10 years, wasn't it?
That is correct, sir.
And as pointed out, Mrs. Corea, that recommendation was agreed to, and it appears every recommendation was agreed to with one exception. So 8 out of 9 were agreed to. The completion date was given as November 2012. And when you went back in January 2014, responded to, is that right?
That is correct, sir.
Now, the result was that part of this follow-up audit, you, the internal audit department made a number of follow-up recommendations.
It may be worthwhile just touching on recommendation 7 on page 1744.
Certainly.
Right.
Can I take you, please, to page 1744? And we'll use that as our example. Recommendation 7, which the follow-up audit report marks as not implemented, is this. It's also recommended that whenever a decision is made by Cabinet or the board to deny approval of status for an applicant, clear reasons as to why the decision was taken should be documented, especially for those cases where the board has made a recommendation and it was denied by Cabinet. This will help to ensure that transparency, equitability, and justification behind the decision taken. Now, the management response was to agree to that and to say that the Premier's office will write this into the Cabinet decision section of the Cabinet papers. What the follow-up audit noted was, in terms of action taken, no action has been taken in this regard. The desk officer within the Premier's office, and the desk officer was identified as the person to take corrective action. The desk officer stated that contact has to determine how best to implement this recommendation. No new date was given as to when this will be done. The audit department then made a follow-up recommendation. As this recommendation has much bearing on the transparency and equity of the decisions made on applications, It is recommended that this effort be undertaken as a collaborative effort with the Cabinet Office Secretary's Office to implement this recommendation. It will also allow personnel involved in the process to be better informed on decisions made. This isn't the only example of follow-up recommendations that were made as a result of this audit. Once you've done that, this is an example that you come in June 2012, you audit, you make recommendations, they are agreed, you come back 18 months later, little, if anything, has been done, you make follow-up recommendations. Does that, for your department, bring matters to an end, Mrs. Corea, or what else can you do after this?
Sir, that's how the cycle evolves. And it's like a rabbit running around in a track. Because as much as we have completed the audit cycle, have done a follow-up process, the implementation of the recommendations still are not made. So for the internal audit department, we find ourselves at a roadblock. And that is why we need the internal audit advisory committee to drive the implementation process for responsiveness to our reports.
But you're dependent essentially on, in a situation like this, where 18 months later, little has changed, you are dependent on that committee and a chairman intervening to press a department or a public authority to get things done. Is that right?
That is right, sir.
Because the audit cycle for yourself and your department may mean that you don't come back to this question for some years.
That is correct, sir.
Can I take you, please, to 1747? Is in the same document. And if I may, Commissioner, I'd just like to read some of this into the record.
Yes.
Under the heading Additional Matters, the follow-up audit said this: a sample of 38 persons was selected to review the process flow of their applications. In 2011, a list of 224 persons was produced for persons whose belonger status was approved illegally. 6 persons identified on this list also formed part of the current sample. The review revealed that the 6 applicants, who although initially were awarded belonger status, were required to go through the established process as the status initially approved was done contrary to the legally established process. They were subsequently awarded status on the recommendation of the board and the reapproval of cabinet. It was also discovered that at the time status was initially awarded in 2011, all of the applicants had an application submitted to the Department of Immigration for consideration. However, they were never interviewed or subject to any other criteria of the established process. It is uncertain if all persons appearing on the list of persons who receive status contrary to the established process have had to go through the board to receive their status. Documents reviewed at the Premier's office indicated that the decision to have persons who were awarded status contrary to the process go through the established process was based on the advice from the Attorney General's chambers. And you then refer to a memorandum dated November 14th, 2012. Although this memorandum spoke to the awarding of residency status without consulting the Board of Immigration, the same applies to belonger status. As also indicated in the advice provided, if persons appearing on this list were in fact given status without any consideration or evaluation by the board, their statuses can be questionable and the process can be subject to review, as the manner/process through which the status was awarded was contrary to the relevant legislation. Additionally, where legislation stipulates that one decision-making body is to consult with another prior to making a decision or conducting an act, there are reasons why such provisions or guidelines are made. Provisions such as the appointments of boards or committees are to provide additional procedural safeguards to aid decision makers. When decisions are made outside of such established safeguards, they increase the likelihood for the decisions to be questionable and possibly subject to legal review. The remaining applicants that comprised the sample reviewed were found to have been awarded status as outlined by the established processes. No instances were identified whereby names were added to the list that was recommended by the board, as all names reviewed were recommended by the board, approved by cabinet, and subsequently awarded status. What you, as I understand, on this small sample, what the audit department was able to assess in the follow-up was that taking a number of applications that they appeared to be being done by the established process. Is that right?
That is correct, sir.
But what you weren't able to do is, of the 224 that you had identified in 2012 as not having gone through the process, it remained uncertain how many of those had had their applications revisited and had been asked to go through the proper processes. Is that right?
That is right.
What you say, and this is at 1748, or what the audit report says, is under conclusion, the belonger application process has not undergone any significant change since the submission of the audit report in 2012. Therefore, much of the issues expressed in that report remain unresolved, and therefore most of the risks expressed in that report remains unaddressed. And that illustrates, doesn't it, Mrs. Corea, why the committee is so important? Because if they're not able to press this issue with public authorities, it essentially could, the risk is that things continue as before and improvements are not made.
That is correct, sir.
And so the concerns that the internal auditors raise, which are intended, and the recommendations they make to improve efficiency and effectiveness, essentially fall by the wayside, don't they?
They do.
Thank you. I'm going to go on to another report, and it takes us back to the first bundle. Can I check, Mrs. Corea, are you happy to continue, or would you like a break?
A break would be preferred. Thank you.
Yeah, I'll ask the Commissioner for a short break.
Yes, we'll break for 5 minutes. Thank you, Mrs. Corea.
Thank you.
Thank you, Mr. Rice.
Welcome back, Mrs. Corea. I'm going to take you to another report, but can I just, before I do, clarify one detail about the belonger status process report that we were looking at. You'll remember that the first report in that audit was produced in June 2012, and it looked at the years 2009, 2010, and 2011. As you may remember, there was an election in 2011. The House of Assembly was dissolved on the 13th of September 2011. There was then the election on the 7th of November 2011, and the first sitting of the House was on the 8th of December 2011. So can you help the Commissioner with this? In relation to that audit, was it looking at belonger applications in 2011 before the election or after, or both?
Before.
Before.
Thank you.
Let's go to page 65 in the bundle, please.
Which page?
Page 65, please.
Yes, thank you very much.
You got it, Mrs.
I have it, sir.
Thank you very much, Mrs. Corea. This is part of a sequence of reports in which the Internal Audit Department, and at that time it was called the Internal Audit Unit, looked at assistance grants programs. And this is the first in the sequence. It's from May 2009, and it's looking at the grants programs from 2006 to 2008. If you go to page 68, and I'll take you through the introduction so that we have some background to the reason for the audit. At 2.1, the report records subhead 62410, open bracket, assistance grant program, close brackets, first appeared in the 1997 recurrent budget estimates of revenue and expenditure, with its supporting note being, quotation mark, to cover the cost of minor stroke territorial projects submitted by elected members, end quotation mark. At its inception, the funding for the program was limited to $60,000 per district representative and $75,000 per territorial representative. The next paragraph reads as follows. Over the years, the program has evolved both in usage and funding. Presently, the program is widely used to provide financial assistance to individuals and organizations throughout the territory, and also to finance constituency offices. Development of minor district or territorial projects accounts for less than 1% of actual disbursements from the funds. For the period under review, 2006-2008, approved funding for the program was $60,000 for each district representative and $75,000 for each territorial representative. This represents a 50% reduction from the 2003 allocation. In 2008, the allocation was increased by 150% from the base year 2006. And so what we see in this part of the report is that what the scope of the audit was to look at financial disbursements from the assistance grant program facilitated by the Legislative Council / House of Assembly between January the 1st, 2006 and December 31st, 2008. If we go to page 69, please. You say, and this is under facts and findings, under general, it was discovered that there are a number of other government agencies that administer similar programs for which funds from the assistance grants are used. These include, at 7.1.1, the public assistance program administered by Social Development. Decisions on applications from this program are made by the Public Assistance Committee after assessments and reports from social workers. Assistance currently being provided include family and individual grants, emergency assistance, assistance with utilities and funeral grants. Therefore, the grant program facilitated through the House of Assembly is a clear duplication of the efforts already established by these structured programs. 7.1.2, the Ministry of Education also administers an assistance grants program which provides miscellaneous grants to students and organizations and committees. And you then say, based on the assistance offered by these already established programs, the audit team is at a loss as to what necessitated the evolution of this program from its original intent of facilitating minor district projects to one where elected members are solely responsible for deciding who is granted funds from the program. So can I, just to understand, I appreciate that obviously you were not at this point, 2009, the director of the, what was then the internal audit unit. But was the understanding of the audit that this program had simply just evolved and changed without any real sort of guidelines or criteria or review of what its purpose was?
And it did so dramatically, so yes, that's the situation.
We go to the next page. Heading grants guidelines. The audit report records the assistance grants program is regulated through guidelines developed and agreed upon by the members of the House of Assembly. These guidelines lack objectivity and are easily changed at the members' discretion. If we go, please, to if I read 7.4, and then I'll look at the guidelines in more detail. What the audit report says is these guidelines are grossly inadequate, as they are in some cases difficult to enforce, contradictory, and vague. And at 7.5, the audit report says, in majority of cases, the guidelines are not enforced as the department has failed to create the necessary controlled environment and activities to manage the function effectively. Where the audit report was referring to the department here, is that referring to the House of Assembly itself as the department?
Yes, that is correct, sir.
Now, if you go to 78 in the volume, the audit report had as an appendix a sort of document which set out the various of the guidelines and raised deficiencies with a number of them, and I'd just like to take you through those. The first guideline is guideline number 1, and it's under general guidance. And its assistance to self by all representatives is prohibited. Self, and self is in quotation marks. Self for this purpose is defined as a grant of whatever nature to the relevant representative, his/her spouse, parents, offspring spouses, siblings, or sibling spouses. Now, what the audit unit said in response to this was, this guidance lacks enforcement mechanism in that representatives are not required to submit a list of family members to the clerk, not prohibit members from entering into contracts with relatives. Reimbursement for utility payments incurred at district offices is submitted without supporting documentation. Does not prohibit members from providing assistance to other members of the House of Assembly. A second guideline which the audit unit had concerns about was guideline number 2, which is as follows. Assistance to companies in which representatives have a majority ownership interest is not allowed. And the point is made by the audit unit that this guidance contradicts the prohibition of assistance to self, because members with minority interest in companies also benefit personally from any assistance rendered, hence it is assistance to self. You then went on to look at guideline number 11, which reads as follows. Assistance is prohibited to any organization not registered and operating in the territory, or for projects not being carried out in the territory where a BVI lender is not a beneficiary. And the audit unit made the following comment. This guidance is difficult to enforce since the office does not have access to an adequate registry of companies and databases of BVI nationals. Now I'm going to pause there. That when I say, when you're referring there to the office, again, is that the office in the House of Assembly?
That is correct, sir.
The audit unit's report then went on to look at guideline 13, which reads as follows. Representatives are not to entertain applications from members of staff of the Office of the Legislative Council from this subhead, for the reasons that 1, members of staff would have an unfair advantage with respect to, quote, inside information, end quote. 2, members of staff would compromise their professional objectivity. And 3, members of staff seeking such assistance would call into question the overall integrity of the office of the House of Assembly, except in the rare instance of medical and educational need. Any such request should be vetted by the clerk before presented to the representatives, and any money granted should be paid directly to the medical or educational institution. And what the audit unit has recorded here is this guidance is not fully enforced, as it was discovered that requests were made by some staff members. These requests were honoured and checks were made payable in their respective names. So just so that we're clear, what this guideline is intended to stop is members, those who work for representatives, being able to claim under the assistance grant program.
Correct.
And what the audit found that was happening, and the requests were being satisfied, and then checks were not just being paid out, but being paid out directly to the applicant.
Correct.
Guideline 14 is a tracking system for multiple and or repeated grants to individuals and organizations. Is to be implemented by the Office of the Legislative Council for representatives' information for the avoidance of exploitation by recipients. And the audit unit made 2 observations there. Firstly, a database was created, but it is not used to track duplicate requests. Secondly, it is not clear as to who or what determines what is meant by exploitation. There is no standard for exploitation. For example, can multiple awards or a large one-time disbursement be considered exploitation? Now, the exploitation, going back to the guideline, it refers to exploitation by recipients. In terms of, I don't know whether you can help further with this, but what was the concern about, or why did the audit unit consider it important to have a clearer definition of exploitation?
Because if you have persons repeatedly getting assistance, particularly in this case from the Legislative Council, then there may be a level of, people just getting grants getting multiple grants from different legislative members. So they can be repeatedly getting from the same subhead, but from different members. So that was a concern with that regards.
The next guideline that was identified in the appendix by the audit unit It reads as follows, and it's 15. Completed application forms for assistance should be lodged by the district/territorial representative with the clerk of the Legislative Council as the accounting officer for consideration under the appropriate head and subhead of the estimates approved by the Legislative Council and within the guidelines approved by the Legislative Council. And what's said is this guidance is not clear in outlining who is ultimately responsible for disbursements from this subhead, the clerk or the members lodging the requests. The report then goes on to look at Guideline 16, which records if the application requires further information or discussion, the representatives will be so informed in writing by the clerk of the Legislative Council. The concern that the audit unit raised was as follows. This guidance is not enforced as no documentation was found to reflect the clerk's disapproval of any application submitted. Communication concerning the clerk's disapproval is done verbally. Why, it may be an obvious question, but particularly since I'm asking it of an auditor, why is it important that there be documentation to record what decisions are made or what concerns are raised?
For transparency and accountability, and to make sure that funds are distributed equitably.
Then the last of the general guidelines that the audit unit identified is 17, which records supporting documentation for all requests is to be provided by each applicant. And 3 concerns were raised. Firstly, and to read it out, this guidance is not adequately enforced as from documentation reviewed, it was discovered that awards are made on simple one-line letters indicating financial hardships submitted by applicants. 2, it's not clear as to what the minimum supporting documentation that is necessary for each category, medical, financial, education, etc. And 3, proving that the requests are legitimate by having applicants substantiate their need for assistance. And so from the audit perspective, what you would have wanted to see, again, is an audit trail. It's again sort of evidence that to support the application, evidence that the application had been properly considered, evidence as to the basis on which it was either accepted or rejected. Essentially, isn't it, Mrs. Corea, you would like to see a document trail from start to finish, because that is what you want in order to be show accountability and transparency. Is that right?
That is correct, sir.
Give me a moment, please. Now, what you also, in the audit report, go on to do, and this is at page 80, is to set out a number of additional guidances or guidance as issued by what was then the House of, it still is the House of Assembly, but under financial guidance, the guideline is financial assistance for community organizations such as school, churches, and non-profit organizations allowed, accompanied by supporting documentation of need or rationale. And the comment that's been made by the audit unit is proving that the requests are legitimate by having applicants substantiate their need for assistance. So again, from the audit unit perspective, documentation is key.
It is, sir.
But when you're doing an audit, you want to be able to understand that a legitimate case has been put forward and has been assessed.
That is correct, sir.
The same point is made that the need to prove the requests are legitimate in relation to the guidance, which is number 3, for financial assistance for scholarship. and for educational grants, whether for tuition, textbooks, transportation, or living expenses. The audit unit also raised this in relation to what was guideline 7 under educational guidance, which is requests for payment of taxi transportation services are allowed subject to a signed agreement between the member and a driver showing rates and times of services. And what the audit unit noted was members are not providing the required agreements, or the agreements are not attached to the payment vouchers by the department. From records reviewed, the current rate is $50 per night. However, it's not justified as to whether this rate is economical and if it is being applied across the board. So this was an example of the unit picking up on, in relation to one guideline, that again, there was a lack of justification, a lack of evidence to support the use or how that guideline was being applied. Is that right?
That is correct, sir.
The guideline 5 goes to medical assistance, and it reads as follows. Requests for assistance with medical expenses should be accompanied by evidence from the attending physician, which should be given as soon as possible or no later than 60 days after application is made. And what's said is this guidance is not enforced. And again, it reiterates that the audit unit reiterated the need for applicants to substantiate the need for assistance. The guidelines also allow for the provision of a monthly living allowance. And so a member could give a monthly living allowance to a constituent, and that's under guideline 9. And that guideline reads as follows. The practice of an individual receiving monthly living allowance from more than one representative is allowed up to $400. In any case, serious considerations be given to linking these allowances with the Social Development Department to ensure that in the event that the representative is not re-elected, the individual is not left without means. Individuals already receiving monthly grants should not be subject to evaluation by the Social Welfare Department. And 2 points are made by the audit unit. First, the need to prove requests are legitimate by having applicants substantiate their need for assistance. And second, that the guidance is incomplete since it does not stipulate whether each member is allowed to give $400 or the total allowance by all members should not exceed $400. So it wasn't clear whether somebody who is going to get this kind of assistance has a cap of $400, whoever it comes from, or it's possibly open that more than one member could give the same person up $400. So one person could be receiving 400 and another person 800.
That is correct, sir.
The final 2 guidelines that the audit unit raised concerns about relate to district expenses. And in guideline 10 noted, district office expenses relating to rent, staff, and operating expenses are allowed up to a maximum of $24,000 per annum. And what the audit unit recorded was from records reviewed, it's apparent that the amount of $24,000 per annum is insufficient as members with district offices exceed this limit. So to be clear, what did the audit find that members were going over the 24,000 in order to pay for district office expenses?
In some regards, yes.
What's also noted is district projects are allowed from the grant. Where a project exceeds 7,500, it should be accompanied by proper bills of quantity approved by the Public Works Department or a recognized engineer or architect. What the audit unit noted in relation to this guidance is being followed to some extent, as some minor district projects such as bush trimming and drain clearing have bill of quantities prepared by PWD. However, it was discovered that not all of the minor districts projects have bill of quantities attached. In some cases, the supplier's submitted cost was used. So again, an example of a guideline where it wasn't being followed by those involved in this process, was it?
That is correct.
And in relation to that one, number 12, the reference to minor district projects. That's the one guideline that relates back to the original purpose of this grants program, isn't it?
Yes, that was one of the initial bases that was formulated for this grant program.
If we go back to page 70, um, 70, and I won't go through the detail of it, but the audit examined the usage of assistance grants, and you did that by looking at the way the different types of disbursements that were used. But if I take you to 7.9 on the next page, 72, page 72, sorry, 2 pages along. The audit unit identified a lack of adequate control and regulation, and the report records this. As a result of the lack of adequate controls and regulations, a number of situations were discovered which can be viewed as a conflict of interest, a breach of both the House of Assembly guidelines and the established procedures for committing public funds. And you give 2 examples. Firstly, the practice of entering into contractual agreements with family members, where the member may also have a private interest, such as rental space for district offices. And the second was in one instance, it was discovered where a member made a private commitment with a financial institution to assist an individual with mortgage payments. However, public funds were used to satisfy the commitment. In addition, based on the documentation submitted, the member stood to personally benefit from assisting the individual, as the member simultaneously maintained a private business relationship with the individual. At that time, and this is obviously, we've got to put it in context, it's a 2009 audit. Aside from the guidelines that we've looked at, was there any other guidance that you can recall given to members or given to the clerk of the House of Assembly in terms of identifying conflicts of interest?
Not that I can recall, sir.
What the audit also revealed was, I think, what the audit unit questioned as perhaps grants that were going beyond the scope of the program, because you give these examples. Firstly, and I'll quote, in one instance, it was discovered that a grant was awarded to an inmate of HM prison to provide assistance to appeal his conviction. In another instance, an award was granted to pay the court-imposed fine for criminal conviction. These 2 instances illustrate the unrestrained use of the funds, as both awards were made on the basis of financial hardship, end quote there. And when the report is referring to the unrestrained use of the funds, does that mean that it was really down to the member concerned to interpret the guidelines and use their discretion as to whether they would award us a grant or not?
Yes, because the member would recommend that the grant be issued to the applicant, and then the clerk would be responsible for effecting whatever the grant amount was.
Can I come back to the role of the clerk in a moment and what was understood by the audit unit at that time? What's also said, and this is at 7.11 on page 72, and I'll quote, it was discovered in a number of cases that representatives granted awards to individuals to settle outstanding bills which were due to other government agencies. Examples of these included assistance to pay water bills and income taxes. This practice shows that government is essentially granting assistance to pay itself, and therefore does not portray government receiving any revenue, as the money given as assistance is government funds. So in effect, there was no money coming into government. What was happening was that government money was just being recirculated.
Exactly, sir.
Now, I said I'd come on to the role of the clerk of the House of Assembly, and you deal with that, or the report deals with it, at 714 on page 73. It explains there that the clerk is the accounting officer for the House of Assembly. However, the clerk lacks the necessary authority to make expenditure from this subhead without the express consent of the elected representative. This begs the question, as the accounting officer for the House of Assembly, where does the clerk's responsibility and accountability end? And you go on to say, or the report goes on to say, the audit revealed numerous instances whereby assistance was provided to individuals based on letter submissions from the members and disbursements being made without requesting the member to substantiate the request. And it concludes that this is at 7.17. There is no communication structure in place throughout the program to disseminate information that would allow applicants to be informed on the status of their applications and members to be aware of competing requests. The success and failure of the program is heavily dependent on an adequate flow of vital information that facilitates a control environment where risks events such as over expenditure can be detected or even prevented. Bringing those together, and again, remembering we're in 2009 now, Mrs. Corea, at that time, what did the audit unit understand the role of the clerk to be in this process?
The role of the clerk is to be the accounting officer. And the accounting officer is responsible for all expenditure from the government subhead to which they are entrusted. The members would make recommendations to the clerk, but the clerk is still responsible to hold up accountability and make representation for those funds in which she or he is entrusted.
So ultimate responsibility for justifying how funds for which you are the accounting officer lies with the clerk.
Correct.
So if the clerk is simply put in a position where they are just agreeing to members' recommendations, they're not fulfilling the role of an accounting officer, is that right?
And that is my question when it says in 714, where does their responsibility end? Because not only are you supposed to undertake the recommendation, but if it's not facilitated in the proper manner, appropriate evidence and appropriate documentation, there should be a question as to whether it should be expended or not.
If we look at 7.8 on the next page.
7.18.
7.18, I'm sorry, yes, thank you, Commissioner. At 7.18, what the audit unit's investigation said was this: adequate control mechanisms are not in place to safeguard public funds through the assistance grants programs from abusive practices. And it then made 2 points. The first is that the program relies heavily on limited human checks as a control to detect duplicate requests. As a result, the likelihood of duplicate requests going undetected is significantly increased. And secondly, as the accounting officer, the clerk has the final authority to approve, disapprove any disbursement from the assistance grant subheads that in his her opinion is questionable. However, the audit revealed that it would be difficult for the clerk to exercise this right, since it has become the norm for members to solely approve requests. Clause 6.1 of the Public Financial Management Regulation states that, quote, if an accounting officer believes that to comply with the direction given to him by the minister would be inconsistent with the officer's duties, the officer shall give the minister written notice of the officer's disagreement and the reasons for the disagreement and place a copy of the notice on record. I'll just break that down a little bit, please. Firstly, if you go back to 7.18.1, you refer to the limitations where you have human checks. At that time, what would have been an alternative process that could have been put in place in 2009 so that you weren't relying on human checks?
Remember earlier in the report, it talked about a database that you can actually rely on that data to do the checks and balances, whether it's for duplication or whether it's for verification. Those are processes that you can utilize to enhance where there's the lack of human support.
And in relation to 7.18.2, does it follow from what the audit unit report said there? Was that the clerk, at least in 2009, was in an impossible situation because members were approving requests, and so the clerk wasn't really able to act as accounting officer and in effect question any request? Was that what the audit showed?
Yes, that's what it showed.
If you look at 7.19, it says the budget for this subhead is determined by the members of the House of Assembly during standing finance deliberation. There is no discernible trend between funding and needs. However, there is a correlation between administrations, open bracket, government of the day, close bracket, and funding. Again, Mrs. Corea, I appreciate that I'm taking you quite a bit back in time when we're looking at these reports, but can you clarify or elaborate any further as to what the concern was in 7.19 about the absence of a trend between funding and needs, but the existence of a correlation between administration and funding?
If you're going to have an assistance grants program, there's going to be some historical information that you would have to look back at to verify your need for future use and purposes. And I find that even in the process of standing finance, that is not a way of looking at budgeted funds. Sometimes it's just a mere practice that this is how much we expend and the possibility of needing additional funds. So therefore, the budget is increased. And when it says the administration, between administrations, I guess different administrations have different views. So to have the funding increased would be a view of maybe an old administration as opposed to a new one. That is all it's saying in that regards. But in terms of funding and need, we should be going off for historic information instead of just the mere practice of just giving grants.
I see. So what you, as an auditor here, what should be happening is that there should be some assessment of how the funds have been used in order to make a decision of how much should be awarded going forward, how big the grants program should be.
That is correct, sir.
Rather than it being perhaps just driven by the decisions of the administrations of the day, because one administration might want an increase, another might want a decrease. And so need isn't brought into the picture.
That is correct, sir.
Can I just take you, before we leave that page, just to 7.22? It was noted there, the audit revealed that the manner in which assistance is granted to applicants is very subjective and therefore begs the question as to why an applicant requesting $3,000 receives a grant of $300 and an applicant requesting $5,000 receives the requested amount. In both instances, the level of supporting information was the same. And does that again go to the concerns that the audit unit raised about the guidelines and how effective they were?
That is correct, sir.
Because you could have a situation where two members of the House of Assembly presented with the same information and approaching it diligently could still reach a different view. And one could award less and another one could award more than the amount requested.
That is correct.
Now, we'll, at 75, page 75,
And if I must say one thing before we move on, in issuing requests that were made by application, it is the discretion of the minister to determine if the person will receive and how much the person will receive. It's at the minister's discretion.
In this case, it's the member that decides, isn't it?
By the member's discretion, correct.
And I think that clearly emerges from the audit unit report. So the member makes the decision and it goes to the clerk of the House of Assembly as the accounting officer.
That is correct.
Now, the recommendations are at page 75. I won't go through them all, but I wanted to draw your attention to 8.3 because, you made two long-term recommendations, and by you, I mean the audit unit. Firstly, that consideration be given to transferring the funding from this subhead to agencies that have already established similar programs. And so that recommendation would essentially dispense with this grants program as it related to the House of Assembly, but transfer the funding elsewhere. Is that right?
That is correct.
And second was that, and this was the long term, recommended that an appropriate budget be prepared for the program with the view of returning it to its original purpose of providing assistance to finance minor district projects. So I think, to be fair to the audit unit, the recommendation wasn't scrap it altogether. It was return it back to its original purpose, and transfer some of the funding to other established programs.
That is correct. To me, it would be more beneficial and effective if you do that.
Now, there were a number of short-term recommendations made, which were quite specific in terms of the operation of the system. So I only need to draw your attention to one of them, and that's at 8.3, where it said, it's recommended that the present guidelines be revised by an independent body to eliminate any inconsistencies which may exist. It is further recommended that such guidelines be formally adopted by Cabinet to better regulate the use of this subhead in the long term. Now, I wanted to draw attention to that because I want to now take you to another report in the bundle, which is the follow-up audit that what had become the Internal Audit Department then did, and that was in March 2011. You'll find that at page 554 in your bundle. Now, 554 is a report headed Follow-up Audit Unit. Sorry, I'll read that again. Follow-up Audit Review, Assistance Grant Programs, 2006 to 2008. It's dated March 2011. And it's still by the Internal Audit Unit. If you look at 556, which is the introduction, what's recorded there is the Internal Audit Unit has completed a follow-up review of the House of Assembly Assistance Grants Programs resulting from an audit conducted in March 2009. The objective of the follow-up review was or were to determine whether management had taken corrective action or implemented the recommendations, and two, to determine whether the desired results were achieved or if management has assumed the risk of not taking action or implementing the recommendations. And what's noted as well is that the report of March 2009 had highlighted some deficiencies that required corrective action. These deficiencies relate to the manner in which the programme is administered, the purpose of which funds are being dispersed, and the lack of adequate guidelines. Now, in doing, and this is about the approach of the audit unit, but in doing this follow-up, the unit held meetings with the clerk, who would be the accounting officer, the deputy clerk, and other members of staff. And what was recorded in your follow-up report was this: the clerk noted that attempts were made to address the weaknesses discovered in the current guidelines. However, this was not accomplished due to the lack of cooperation from some members of the Assembly. It is imperative to note, the clerk, in her management response to the report, stressed on the importance of adopting clearly defined guidelines that would allow for transparency and consistency in administering the programme, with an anticipated completion of 10 months after the issuance of the report, March 2010. So does it come to this, Mrs. Corea, that your March 2009 report is submitted and it goes to the department in this case, or the authority that you're auditing, is the House of Assembly. And the person that responds in terms of a managed response is the clerk to the House, who anticipates that there would be a completion of the recommendations within 10 months. So by March 2010, when you go back in March 2011, or September, March 2011, the position is, isn't it, that none of the 10 recommendations that had been made in 2009 had been implemented. Is that right?
That is correct, sir.
And the one reason that seems to have been given to the audit unit was a lack of cooperation from some members of the Assembly.
That is correct, sir.
So it's not a lack of will on the part of the public officers concerned. It was that members of the House of Assembly were not happy with the recommendations made.
That is correct, sir.
Now, the audit report at 557 said under follow-up procedures, as a result of not implementing the recommendations provided in the report and not taking any other corrective action to address the issues identified, follow-up procedures were conducted to reassess the risk and impact of not taking action. The results of these procedures are as follows. 1, the review found that there were no changes to the current guidelines, to assistance grants usage, and to the manner in which the programme is administered. And under 1A, what was noted was financial, open brackets, hardship, close brackets, educational, medical assistances continue to be the main categories of disbursements made from the assistance grant subhead. These disbursements are still being made in a manner inconsistent with the original intent of the subhead, which is to finance minor district projects. B, there were numerous instances where assistance was provided to individuals to pay their living expenses and debts, such as house rent, utility bills, mortgage, car loan, cart fines, and child maintenance. And C, most importantly, there were no changes made to the control environment for which the assistance grant programme is being administered. The programme still operates from weak controls, minimal enforcement of requirements, and inadequate oversight. Such an environment increases the likelihood of impropriety. So, in effect, the position had not improved and the risks were still there.
That is correct, sir.
The follow-up in terms of recommendation was, and I'll quote this, "It is highly recommended that the recommendations provided in the original report be implemented expeditiously." And 2 other recommendations were made. Firstly, that the advice of the Attorney General be sought in relation to the perceived conflict that exists where the accounting officer may not have authority over the assistance grant subhead, as outlined in the description in the budget estimates. Does that go to the point that although the clerk of the House was the accounting officer, still in March 2011, the clerk to the House was not the person, was not in a position to question any approval.
That was a situation, sir.
So not, in actual fact, not really able to operate as a proper accounting officer.
That is the case.
Before we leave that, do you know, and the answer may be no to this, Mrs. Corea, but do you know whether advice was obtained from the Attorney General?
I am not aware.
The next point that was made was that it's recommended that the clerk, as accounting officer, become formalized and guided by the following clauses of the Public Finance Management Act 2004 and the Public Finance Management Regulations 2005, and you then set out a number of clauses. Was that recommendation intended to put the clerk to the House of Assembly in the position where they knew what their role was as accounting officer?
Pleasant reminder, sir.
The conclusion that was made at 558 by the follow-up audit is as follows. As articulated in the report, the funds dispersed from the Assistance Grants Programme as public funds must maintain the same level of documentary evidence as any other expenditure and must be accounted for in a like manner with the same level of accountability and transparency in compliance with the public finance management laws. With this in mind, and 1 year after the anticipated date of completion, it must be noted that the House of Assembly has not made significant effort to implement any of the recommendations and has not taken any corrective actions to address the issues raised in the report. Although management has provided some explanations for not implementing the recommendations relating to the assistance grants programs, it is essential that every effort is made to correct the vulnerabilities and the deficiencies identified in the report. Management cannot remain non-responsive and must assume the responsibility for any risk event resulting from the existence of ineffective systems and controls. The recommendations provided in our opinion, I'll just read that again. The recommendations provided in our opinion were designed to address the most significant weaknesses in the control environment and when implemented would help in improving the administration of the program. The House of Assembly is therefore encouraged to implement the recommendations of the report and the follow-up recommendations where possible. Now, it's perhaps important to stress what the audit unit is doing. It's not your job to say whether a policy is right or wrong, is it? You're just looking at whether it's efficient or effective, and the risks are manageable.
That is correct, sir. And
in doing this, I mean, this is in March 2011, so perhaps just shortly before the Internal Audit Advisory Committee was set up and the Act came into play. But now that you've done a follow-up audit, it was that there's nowhere further for you to go with this issue, is there?
No, there isn't, sir.
It's entirely dependent upon a committee, and I think in that point you said that there was at one point a committee made up of permanent secretaries. Was that committee in place in 2011?
No, sir, it was not.
And nor did you have an didn't have an internal audit advisory committee until 2014, did you?
That is correct, sir.
So at this time, 2011, having done the follow-up audit, there's nowhere else for the internal audit unit to go, is there?
No, there isn't, sir.
Just want for, can I take you back to page 63, please? Sorry to make you jump around in the bundle, Mrs. Corea.
That's okay.
And I think it's, in fairness to all, perhaps important to put this detail into the record. I've taken you to a letter dated the 19th of May 2011, and it's addressed to Mr. Wendell Gaskin, the Director of Internal Audit at that time. And it's from the Speaker the then Speaker of the House of Assembly, Roy Harrigan. And what Mr. Harrigan communicated to Mr. Gaskin was this. At a meeting of elected members of the House of Assembly held on 5th May 2011, I was directed to convey to you the position of members with respect to your Internal Audit Unit report, May 2009, on the Assistance Grants Programmes, and your follow-up audit review of the same programme, open brackets, March 2011, close brackets. What was then raised, and I will summarise this in the next paragraph, was a point was taken that it was not the job of the Internal Audit Unit to audit the House of Assembly. That was the audit unit did not have the authority to do that. The letter then continued. In 2005, the Assistance Grant Programme was expanded to include persons experiencing certain hardships. Along with this expansion, members felt they have a good idea of what happens in the community. Members reported that they use their discretion to give funds after hearing from the applicants. Their resolve is that this discretion must be left with the elected members. Further, members said that they are at a loss to perceive what mischief is being corrected by the recommendations in the reports. There is a general sentiment among members that there is no impropriety as far as they are concerned, and that the Assistance Grant Programme is being handled the way they want it done. According to members, the Assistance Grant Programme must be kept simple and not complicated or encumbered by a lot of paperwork. However, members are aware that there will come a time when the programme will have to be overhauled, but until that time, they will continue to have the allowances and give assistance in their usual way. And the letter ends there. Now, perhaps I will read, and this is at 60 in the bundle. And this is a letter of May 27th, 2011 from Mr. Gaskin addressed to the Honourable Roy Harrigan. And again, I'm going to summarise, Commissioner, if I may, but yes. The first paragraph makes this point that, and Mr. Gaskin respectfully points out that the letter should have been written by the Clerk of the House of Assembly rather than the Speaker, because the Speaker neither has constitutional nor legal responsibilities relating to the matters under review. Mr. Gaskin then sets out the basis on which the Internal Audit Unit has a proper right to audit this particular programme. And then he continues as follows. Contrary to the member's assertion that disbursements from the fund are discretionary, this assertion is invalid since disbursements should be guided by the guidelines produced by the House of Assembly. Please refer to the note provided in the Appropriation Act. Another misconception that must be addressed is that members are of the stance that the report was produced to highlight the mischief being perpetrated by them through the programme. As a practice, this office endeavours to conduct its engagements objectively and unbiased, report the facts as found, and offer recommendations that add value or improve the processes. Furthermore, this office has not and will never attempt to dictate to any accounting officer how to manage their finances. What we do is offer sound advice on the effective management of such in compliance with our financial management laws. We have again reviewed our reports and are too at a loss as to how the members deduced from their contents that we are making recommendations to correct some mischief being perpetrated by them. The report continues as follows, quote, "The most troubling aspect of your letter is that the members believe that the Assistance Grants Programme is being handled the way they, the members, want it done. We staunchly disagree as to the disbursements of public funds." I'm sorry, I'll read that again. "We staunchly disagree as the disbursement of public funds is governed by the Public Finance Management Act and regulations. Although the law does not explicitly bind members of the House, the Accounting Officer of the House of Assembly, who approves the disbursements, is bound by the standards set forth therein. Section 21(2) of the Public Finance Management Act 2004 expressly states that, quote, accounting officers are personally accountable for public funds received, collected, or dispersed from monies appropriated. In addition, the accounting officer, according to Section 73 of the Public Finance Management Regulations as amended, must certify the accuracy of disbursements in addition to ensuring that they are adequately supported. We are at a quandary to comprehend what is meant when you said that, quote, the assistance grant program must be kept simple and not complicated or encumbered by a lot of paperwork, end quote. We are not suggesting that the process be overly complicated or cumbersome. What we are advocating is that there should be a minimum standard of documentation to support disbursements from public funds. We are just asking that the House of Assembly, in administering the program, maintain sufficient documentation to promote transparency and accountability, which are fundamental principles of good governance, a responsibility for which the members should lead. Mr. Gaskin concluded his letter as follows, quote, in closing, it would be enlightening to know what conditions must exist that would warrant an overhaul of the assistant grant program. Would it not be more prudent to correct the issues as identified by being proactive rather than reactive? We hope that this letter is received with the sentiment in which it is sent and that it clarifies any misconception that the members may have as it relates to our authority and to the audit of the assistant grants program. It is our hope that the recommendations provided will now be accepted and implemented. Now, just again to reiterate, Mrs. Corea, you cannot compel an accounting officer, and this is you as the internal auditor, to follow particular rules. That's ultimately the accounting officer's responsibility. Is that right?
That is right.
All that you can do as the internal auditor is to point to risks. You can highlight where a rule may not be being appropriately applied and then identify the potential risk.
That is correct.
But ultimately, as we've seen now from some two sets of reports, there comes a point, doesn't there, was as the internal audit department, having made follow-up recommendations, there is in effect nothing more that you can do.
That is correct, sir.
Unless you have an internal audit advisory committee available to add an additional level of pressure, for want of a better word, or encourage. I'm sorry, I spoke over you. Could you just repeat your last answer, please?
I said that is correct, sir. And that would add to the existence of the internal audit department and its achievement of its goals and objectives.
Does it, the commissioner has previously received evidence from members of the House of Assembly about the assistance grants programs. And some of that evidence is from members of the House of Assembly applying the program some years after your follow-up audit. Some of them, in 2019 onwards. Would it come as a surprise to you, Mrs. Corea, to learn that the guidelines which have been provided to the commissioner are exactly the same guidelines that your team reviewed in 2009?
No, it's not surprisingly.
Sorry, I'll clarify. The small changes that have occurred is just simply where it's legislative council, it's changed to House of Assembly. But other than that, they're the same guidelines. Does that surprise you?
No, it does not, sir.
And why doesn't it come as a surprise, Mrs. Corea?
Because I have recently looked at the guidelines and I realized that they have not changed.
Thank you. Commissioner, I've reached a convenient point and I'll be moving on to another report. So perhaps this might be a good time to allow Mrs. Corea a break for lunch.
Yes. Shall we say half an hour, 20 to 2, Mrs. Corea, if that's okay?
Thank you, sir.
Good. Thank you very much.
Thank you,
Mr. Rowett.
Thank you.
Mr. Rawat.
Thank you, Commissioner. Mrs. Corea, we should be at another report that I'd like to look at with you, which is at page 2691 in the bundles. Do you have that report?
269.
It's in 3.
Yes.
We should be at a report of the Internal Audit Department dated August 2014. Government Ministry, the title of it is Government Ministries Assistance Grants Programs. And it's headed or marked as a draft report. So that's a report to which there was no management response.
Correct.
If we go to 2693, under the heading background, what's explained is I suppose the route that led to the report, and it's as follows. Assistance grants programs were developed to provide various assistance to citizens who require or need financial help because of various reasons. The government of the Virgin Islands operates various assistance grants programs through different government ministries and departments. Amounts are allocated through the budget process each year, ranging from an approximate cumulative total of $3,237,000 in 2009 to $2,978,100 in 2013. Although the amounts allotted to each ministry may not be significant in comparison to their individual annual budgets, it is important in any service delivery industry that processes are reviewed to ensure that customer satisfaction is maintained. Additionally, it is important to make sure that in administering such programs with public funds, adequate processes and controls are in place to govern the disbursements from abusive practices. And then in the next paragraph, the report notes of the 7 ministries / departments of government, only 5 facilitate assistance grants programs. The reasons for the need for these programs encompass medical, financial, educational purposes, civic and social, religious, organizational, legal, and special needs. If you go to 2.1, which is on the next page, what's noted at 2.1 is the scope of this audit, and it's recorded as being an examination of assistance grants issued for the last 5 years. Assistance grants issued under departments were not included in the scope of this exercise. However, information pertaining to their purpose and structure were considered in evaluating and assessing the programs administered by government ministries. So does it follow, Mr. Gray, that the focus of this audit was on grants being managed at ministry level?
That is correct, sir.
If you look at page 2695 now, you cover in the report, or the report covers audit criteria. The last time that there was any kind of audit linked to the current audit. And then under audit limitations, it's noted, files were requested from the Ministry of Finance and Economic Development and the Ministry of Health and Social Development to assess their request and approval processes for their assistance grants programs. However, these documents were not presented as the Ministry of Finance recently relocated to a new office due to their office being under renovations. Therefore, the files were not readily accessible and as a result were not submitted for our review. The Ministry of Health and Social Development, although having access to their files, stated the files were in unhealthy condition. You've put in brackets there, mold. It was explained that efforts would be made to sanitize these files. However, this was not done within the requisite time frame allotted for the exercise, and therefore the exercise proceeded without this information. And you then say, as a result of these two situations, the auditors relied on information documented within the J.D. Edwards accounting software to present their findings and conclusion in relation to these ministries. Now there you have reasons that have been given by two ministries as to why they have difficulty providing you with information. Do situations like that arise from time to time?
Yes, it does.
And in circumstances like that, where there isn't an outright refusal, but the ministry raises difficulties, what's the approach of the internal audit department?
Well, we try to find alternate ways to accommodate the information that's needed. And in the absence of that, then that portion would not be a part of the audit exercise.
And in terms of recent experience, has it been easier because more and more information is now being held electronically?
In some cases, yes, sir.
And in other cases, are you still having to rely on paper files?
In most cases, yes.
So paper is still used within the public service to quite a great extent?
Widely used, sir.
If you look at 2696, you set out there the and it's two figures, one for the assistant grants programs for 2009 and the one for 2013. That's on the other page, 2697, and just show how the budget for assistance grants is divided up. So in terms of the 5 ministries, certainly in 2013, which is on page 2697, the 5 ministries that administered grants programs were the Ministry of Natural Resources and Labour, the Premier's Office, the Ministry of Finance and Economic Development, the Ministry of Education and Culture, and the Ministry of Health and Social Development. If you go to 9.2 and 9.3, the observation is made, and it links back to what we were looking at earlier, that there are multiple assistance grants programs throughout government. And when one compares that administered by the House of Assembly and those by various ministries, there is an overlap in purpose between the different grant programs. Is that right?
That is correct.
What's noted is that the only difference observed was that the ministry's programs were in most cases based on ministry's subject matter. For example, the Ministry of Education and Culture administers assistance for educational and cultural purposes, while the House of Assembly's program was broader, encompassing grants for all subject matter. And the point is made at 9.3 that some of the duplication within programs may be attributed to a lack of awareness by internal stakeholders that numerous grant programs exist throughout government. And there is therefore a lack of coordination among the various ministries when issuing assistance. Consequently, there's an inability for officers to conduct adequate scrutiny of requests for assistance. Again, could we just clarify that a little? Was the point being made here is that even within the public service and within government, there wasn't sufficient awareness of what other programs were being operated by ministries?
In some regards, so no.
Could you clarify a little bit further in terms of what you mean by in some regards?
For example, since the House of Assembly has a whole wide array of different assistance grant opportunities, some persons were not aware that some of these grant funds can be offered and received in other select areas across government. For example, health and social development. Social development has more grants for social development issues and programs. And at the same time, the House of Assembly also provides grants in that subject matter.
And if you have a situation, as appears to have pertained in 2014, where different parts of government are administering grants or grants programs that cover the same subject matter and don't know the detail of each other, what risks could arise from that sort of approach?
You could have abuse because, for example, scholarships in the Ministry of Education, you have a structured scholarship program where students are issued scholarships to do studies in different areas and capacities. However, you also have the Premier's office awarding scholarships, and you also have the House of Assembly awarding grants for scholarships as well. So it can be an abusive situation where persons are getting assistance grants for the same purpose from different areas.
If we go to 2698, you set out there, or the report sets out there, that objective 1 was to give assurance to the adequacy of the control systems in place to safeguard disbursements from abusive practices. And at 9.4, the observation is made, for each of the assistance grants programs reviewed, it was observed that ministers have ultimate authority to approve requests for assistance. Permanent secretaries stroke accounting officers, although vested with the responsibility by law to manage and account for the funds allocated to various programs, have little to no involvement in the approval or denial of the assistance. And then you make the point that this puts permanent secretaries in a compromising position whereby they are accountable for funds for which, in essence, they lack the necessary authority to approve or deny expenditure without the minister's approval. This in turn misrepresents the role of the accounting officer. I'm going to pause there, but I mean, the observation that ministers have ultimate authority to approve requests, where did that come from?
A person can submit an application, whether in writing and sometimes verbally, to the minister, and the minister, in conversation with that person, will take up the situation and bring it to the attention of the permanent secretary in a decision form. And thereafter, the accounting officer, which is the person responsible for the funds, would issue based on the directive of the minister.
And so the situation across these ministries was very much the way you earlier reports had described the position in the House of Assembly. The accounting officer has no role in making the decision.
In most cases, no. They just follow directives.
And that puts the accounting officer in a difficult position. Is that the view of the audit department?
It is, sir.
And because the permanent secretary in these cases is the accounting officer, what risks fall on the permanent secretary who's placed in that position?
Well, they have to be accountable for the funds, and they have to report on how the funds are being used on an annual basis. So it would put them at risk.
What the audit report also says at 9.5 is that the audit revealed that there are no formal procedures in place within the ministries for requesting assistance. Letters are accepted by all ministries to substantiate requests for assistance. However, these letters are generic in nature and provide little documentation stroke information to support the request. Some ministries, depending on the request, indicated that they would require individuals to submit additional information. However, this does not occur in all cases and is not mandatory, as it was evident from the documentation reviewed. Therefore, the audit could not find any objective basis on which assistance was being approved and denied. Again, was that a finding that ran across the ministries?
Very much so, sir.
And does it follow then that different ministries would have had different processes?
They would have if they implemented different processes, but for the most part, assistance is usually an application by letter, and it goes to, in most cases, to the minister via the permanent secretary. However, at the end of the day, the decision is made, and then the permanent secretary as the accounting officer is required to effect those assistance grants.
What you also say is that, or the audit department says that the control that that's found to be effective in ensuring a grant award is used for its intended purpose is it's paid directly to the institutions for which the applicant requested the assistance. So rather than paying an educational grant to the applicant, paying it to the educational institution is a better course. But what was noted was that this wasn't evident across all grant programs administered by government. As in most instances, grant payments are issued in the name of the person making the request. So what the audit was showing was that there's no system as to how to make an application. And then variability as to whether, when an award is granted, whether it goes to the applicant or goes to the institution that will actually ultimately get the payment. And does that, as you note at 9.6, that leaves the programs open to abuse, doesn't it?
It does.
So stepping back from this, would a better course be for a single transparent process to apply across all grants programs?
Yes, it should have one. So it can be streamlined across all ministries, and then they will have an idea as to what grant programs are available in each ministry to avoid duplication of payment.
If we go to 2700, which is and this is under the heading where the audit report made a number of findings to specific issues that require special mention with reference to the assistant grants program administered by the Ministry of Education and Culture. But what one looks at it in the context of that, there are points here that apply to other grant system programs being administered. So for example, to go through these and summarize them, one of the points that the audit picked up in relation to the education assistance grants programs was that you would have students making applications to more than one program. That's at 9.10.
That is correct, sir.
And that would happen even when, as we see as 9.10.2, persons were only or granted assistance on the basis that they get it once a year. But they could get round that by making multiple applications.
That is correct.
And so the example is given that the audit discovered that at least 55 repeat applications, of which 20 received assistance within the same year. And you go on to say that this indicates these awards were made contrary to the practice and policy, indicates the practice and policy, in essence, is not enforced or adhered to, making it easy for the program to be abused. Another point that is picked up, and this is at 2701, at 9.10.3, the audit did a sample of 100 scholarship students and essentially found that there was a risk that information being put on scholarship applications was possibly false or misrepresented. And that was again something that the system wasn't designed to correct or pick up on. Is that right?
That is correct.
What is also highlighted then is, and this is at 9.11, is that there was no audit of how progress was being made on a package of study, even though that was a requirement. So it was a requirement that students who'd received assistance should submit to the ministry evidence of whether they were making progress on their course of study. But what was found was that in more than 90% of cases, there was no evidence of, for example, a transcript or a program audit being submitted to the ministry. And what's said is, again, a weakness in the enforcement practices of the ministry.
That is correct, sir.
Now, this goes to, doesn't it, Mrs. Corea, the system design? Because if you want a transparency and accountability, presumably you want to be able to have a system in place that allows a fair opportunity to make an application, allows that application to be assessed by written criteria, and allows the system to, the effectiveness of the system to be monitored. So, for example, a ministry is giving out grants. Part of their process should be to ask themselves, do we have evidence whether the grants are working?
Quite so, yes.
And are those the sort of things that an audit would point to, where you have gaps in the system that don't do that? Is that the sort of thing that an audit would pick up on?
Yes, because there should be a system to measure that the objective of the program is actually being met.
If you look at 9.12, the audit did a further sample of requests submitted to the Ministry of Education and Culture. And it records this: the review revealed the following observation, which highlights various means through which the program can be further abused due to the absence of adequate controls to govern the process. And the examples that are given are someone obtaining initial assistance, but then returning to say that the amount granted was insufficient and therefore requesting further consideration for additional funds. And what the point that's made is that that sometimes resulted in multiple assistance amounts being granted, and the initial award being revoked and a larger amount being approved. And this, we find, disenfranchises other individuals, as due to the limited availability of funds, if one person receives multiple assistances, limited funds would be available to assist other individuals. And was that the case, that someone was coming back to the ministry but without really any new evidence?
That is correct, sir.
And so they were just coming back saying, well, my circumstances haven't changed, but the amount you've given me is not enough. They were getting an increased amount. And the point the auditor's making is that because it's a finite pot, that means that there's less for others.
In all due course, yes, that's the case.
And again, at 9.12.2, a point is made that which echoes a point that was made when we were looking at the audit reports of the House of Assembly's assistance grant programs. And that is that grant awards are determined on a discretionary basis, because it was observed that some applicants would request a certain amount and receive the full amount, while others were given less than what was requested. But what you couldn't find was a clear justification to determine how that decision was reached, which meant that there was a risk of unequal treatment in terms of the way amounts were approved. Is that right?
Yes, sir, because they're allowed to use their discretionary powers to decide and determine what amounts are actually granted for the award that was applied for.
And when you say use their discretionary powers, who is the they you're referring to?
The ministers.
And this issue, was that something you saw not just in the Ministry of Education and Culture, but elsewhere across the ministries?
That is correct, sir.
If we go over to the next page. What's pointed out at 9.12.3 is that persons working in the Ministry of Education and Culture could also submit requests for assistance. And the auditor makes the point that when you have that situation and officers are eligible to participate in the programme, special care should be exercised to ensure transparency and accountability is maintained by ensuring that these individuals submit adequate documentation to support their requests, as the perception of favouritism can materialise. And what you say is that the audit found that adequate information such as the costs of programmes, invoices, the submission of grades to support requests were not submitted in all such cases. And leaving aside that there may be the reality of favouritism, in circumstances where it might be perceived that a public officer is being treated differently by a ministry compared to an ordinary member of the public, where there's that perception, that in itself is enough to erode transparency and accountability, isn't it?
I was distracted by the noise. Could you repeat the question, please?
Yes. The part of the report that I've read out refers to the perception of favouritism can materialise, where there is a perception that public officers are getting an advantage over ordinary members of the public. And that perception in itself is enough to erode transparency and accountability, isn't it?
Definitely so.
Because it goes to undermining public confidence in the way the systems work and whether a member of the public can get a fair opportunity to apply for a grant.
That's the case, sir.
You also note, and this is 9.12.4, that requests for educational assistance were forwarded from the House of Assembly to the Ministry of Education on at least 3 occasions. This highlights the question as to whether the Assistant Grants Programme at the House of Assembly can adequately support and evaluate such requests, or whether such grants should be awarded solely by the ministry responsible for the subject matter. I wonder if you could elaborate on that a little further, because we've taken you through the reports now, and you have a situation where you have subject matter grants being administered by ministry, but the House of Assembly grants programme spans a whole range of different subjects. What difficulty did the audit team identify arising from this overlap between these grants programs?
Now, with these 3 occasions, those were 3 occasions that were identified and were picked up. There would be instances where assistance would be requested and actually processed. So when you can identify and have knowledge that the same subject matter can be dealt with at another ministry in their subject matter, you would actually provide that information for the ministry to award that grant. But in cases where you find that there is an overlap, but you don't necessarily pick up or don't have the knowledge that the same assistance program is available in the ministry, then you run the risk of having maybe duplicate payments in some cases, and in some cases, abuse.
At 9.12.5 in the report, the audit picks up on another example, and that was a scholarship being withdrawn from a student because that student failed to maintain the grade point average stipulated by the ministry. But the effect was that the student then made a request for assistance, and which was approved, and that was assistance in order to complete the student's degree. So the student got, as a result of that request, $9,000, which was the same amount that the student would have received under the scholarship. And what's said is that the approval of this request provided a means to circumvent the ministry's policies and highlights the manner in which the assistance grants program can be susceptible to abuse. This case also highlights the communication difficulty within the ministries across the various programs being administered, as there appears to be a clear case of breakdown in communication, where in one program funding was withdrawn, however approved within another program within the same ministry. So does that point though to a wider issue about communication, Mrs. Corea? Because you've got two difficulties that the audit is highlighting, haven't you? Firstly is that the overlap between the purposes of different grant programs risk duplicate applications. And that can only be solved by communication between the different programs. But also, there's even within a ministry itself, there must be communication to avoid, as in this case, somebody getting around the policy, which was you won't get your scholarship if you don't maintain a grade point average.
That is correct.
And so, stepping back from it, and looking across the range of these grants programs, and this is, we must remember, a 2014 audit, what the audit was identifying, wasn't it, was that programs were not being monitored effectively, that there was insufficient guidance in place as to how awards would be granted. And that goes to a lack of, in effect, prudent budgeting. Would you agree with that?
Yes, sir.
If we go to 9.16 on page 2703, please. It begins like this: from interviews conducted, it was revealed that the amount of assistance awarded to a single applicant is left to the minister's discretion. Now, what kind of interviews did the audit conduct? Who was being interviewed? I could help you perhaps if you look back to 5.1. 5.11, you refer to interviewing staff members.
Right, correct. You'll be interviewing the staff members within those ministries who has responsibility over the activity that's being audited.
And so that's public officers that are giving you this information?
That is correct, sir.
And what 9.16 continues is the minister determines the amount deemed suitable based on the need for the assistance and the amount being requested. It was revealed during testing that some applicants received 100% of their request, while others received only 10% of the amount requested. No criterion was found being used to determine how much assistance would be awarded in response to each request. It was conveyed that at times meetings may be held between the applicant and the minister to assist in understanding and determining an amount to approve in response to a particular request, but no documentation of these meetings was found on the files reviewed. The lack of such information removes transparency and equity with reference to the decisions made. Additionally, the absence of clear standards and criterion in approving assistance grants has the potential for the program to be viewed as unfair and non-transparent. Does it come down to this, that it's just up to the minister to decide what criteria should be applied, how much someone should get, how they go about deciding how much someone would get? Was that what it comes down to?
In most cases, because if there's no documentation to support the request, you unilaterally would have the discretion of the minister being applied.
And from an auditor's point of view, if there's no documentation of the process, you have no way of gauging whether the discretion is being fairly applied to all applicants or not.
No, we don't.
And what there is the risk as well, isn't there, that different ministers will approach the exercise of their discretion in entirely different ways.
And that's possible.
Some ministers might want more documentation than others. Some ministers might consider a criterion important. Others may consider it less so.
That is true.
And again, isn't the point that's being made by the auditors is that you end up with a process, however benign people may want to be, but you just end up with a process that isn't obviously, it's not transparent and it's not auditable.
That is the case, sir.
Could I take you please to 9.20 on 2705? And this is about the point we've touched on before, and that is the sort of duplication of programs. So what's said there is that on research conducted, it was found that there are other departments who administer similar assistance grants programs to those of other ministries. Those instances, again, all illustrate the manner in which avenues can be opened whereby persons can exploit the programs to their advantage. And so you point out, for example, that the House of Assembly's assistant grants program is similar to programs administered by the Minister of Finance and Economic Development and the Premier's Office. The Ministry of Health and Social Development administers a special need programs, which, whilst the Social Development Department administers an assistant grants program to persons in need. The Department of Culture, through the Ministry of Education and Culture, administers a program for cultural assistance, but assistance for such subject matters can also be received from the Premier's Office. And just to clarify, but the fundamental risk there is duplicate applications, isn't it?
It is so.
Which means that because there's no effective monitoring, because there's no communication between ministries, some people will succeed more than once, while others won't succeed at all.
That is correct.
Can I just take you now just to the last part of this report, which is at 2707, and that's the conclusion. What the audit report says is this: the assistance grants programs administered by various ministries is largely administered at the sole will of the respective minister. In their current state, these programs lack adequate controls to safeguard them from abusive practices. Various questionable practices have materialized that has resulted in one individual receiving multiple assistances across various programs, and even within the same program. This is largely due to lack of verification activities and the lack of adequate policies and guidelines to govern the administration of the programs. The methods by which amounts are approved and decisions made lacks transparency, which can cast a dark cloud over the programs. While most of the awards appear to have been granted under the particular ministry to which the purpose relates, their evolution, and in some cases their structure, has left much to be desired. Within at least two of the programs, redundancies were identified as they reflect similar characteristics of other assistance grants programs in existence within other ministries and departments. Duplication of resources removes the ability to optimally use those resources in administering programs. It further hampers the program's efficiencies and effectiveness, and thereby at times results in wasted resources and efforts. These programs provide a necessary support for individuals who may not be able to obtain their services without their assistance. However, ministries need to exercise special care to ensure that the process is fair of biases and provides all eligible persons with the opportunity to obtain the help they require. We are aware that due to the limited availability of funds, it will not be possible for government to assist all persons. Ensuring that processes are fair, lucid, and that guidelines are in place to guide decision makers in making decisions and add greater value to the programme and its administration will help to ensure that the programmes are guarded from abusive and fraudulent practices that can create negative perceptions in the public's eye. Now, you had made recommendations, and in total, the auditors made 10 recommendations, including that although the funds are approved at the discretion of the minister, ministries be allowed to conduct adequate due diligence as part of the approval process before processing assistance grants. And so that one would involve the accounting officer more directly, wouldn't it, in the process? Is that right?
That is correct, sir.
You also recommended the development of guidelines and policies to govern the assistance programs. Now, this was a draft report. You got no management response. What happens to the report after that?
It's finalized in draft form. And I bring you right back to the need for having the committee instituted so that we could have that collaboration and have that second arm to enforce compliance to the audit recommendations and implementation thereof.
Because otherwise the report, despite the hard work of the internal audit department, will just end up sitting on the shelf, won't it?
It would be shelved, sir, yes.
And do these reports have do they have a lifespan? Is there a time when, rather than pick it up off the shelf and dust it down and look at the recommendations, the need really is for a new audit to see what systems are in place so that you can see whether the recommendations still have value?
That is correct. So in a case like this where the report ended in draft form, that is what would usually constitute looking back at this same subject matter.
Where you have a draft and you haven't had a management response, can you do a follow-up audit if you want?
We would go back to the report, yes, and identify if, for example, if the accounting officer had changed and there wasn't a response from the current accounting officer, this is an area where we would bring up a report that is in draft and submit it to the new accounting officer to review for further action. In other circumstances, if the findings were grave enough, we would usually utilize, and if they had a financial implication, utilize the Ministry of Finance as an endorsement to make sure that the report is responded to, and then we would have further follow-up after management response is received.
Now, in this case, you were looking at grants programs administered by 5 ministries. So would you have sent this draft report to all 5 ministries?
Yes, this report was sent to all 5 ministries for a response.
And you got no response from any of the 5?
No, we did not.
And so then your recourse is perhaps trying to resubmit it and ask them to look at it again, raise it with the Ministry of Finance, or take it to the committee if the committee is in place?
That is the case, so.
Could we move on to another report now? That's in part 2 of the bundles at 2026.
One minute, sir.
Oh, thank you.
Okay, move forward, yes.
Have you got the page?
The page is, sorry.
2026, please.
Two 2026.
Yes, 2026, and it's in the bundle that's labeled Part 2.
That's with Her Majesty's Customs, sir?
Yes, it should be a letter dated December the 1st, 2015.
Okay, I have it, sir.
Right. This is the reason I wanted to look at this is this is an example of what might be described as a Section 16 report, or where the internal audit department is asked to look at issues of suspicion of fraud. So it's a fraud investigation involving customs. Now, could I ask you, as we go through this report, Mrs. Corea, not to name the people involved or precise locations, because there's no need for us to do that. If we call those involved just importers, that will be enough. If I give some background, and if we go, please, to paragraph 2.2 on page 2029.
Yes, sir.
Again, it's just by way of background. So customs is a revenue collecting agency within government, and it used an electronic receipting system through the JD Edwards accounting software. But in circumstances when the system wasn't working or was down, manual receipt books were used. That's right, isn't it?
That is correct, sir.
And these would be issued by the Treasury Department to, in this case, customs officers. But what they were expected to do is, once the system was back and running, they would put the details back into the JD Edwards software. Is that right?
That is correct, sir.
Now, the last bit of that paragraph 2.2 says this: if manual receipts are not entered into the system, then the cash book clearance process is used. Could you just explain what the cash book clearance process is, please?
Okay, once you have collected revenue from any customer for the purpose of the accountant general, you would write a receipt. It is lawful to write a receipt every time you collect revenue. There are times when, because we're electronic, there are times when the electronic system is non-functional. There is the process of manual receipting. Manual receipting is handwritten and issued to the customer, likewise an electronic receipt. Once the system becomes active, the officers are required to input the information on manual receipts into the system. There is also a cash book system where you would log all your revenue at the end of the day in a cash book. This cash book is usually taken to the Treasury along with your receipt books for reconciliation.
Thank you.
And if I do recall, it would also incorporate your deposits that were made. Sorry.
So your voice dropped a little. Could you just repeat that, please? You said
I was saying, along with your receipt books and your documentation in your cash book, if I recall correctly, you will also identify your deposits that were made for the cash transactions or whatever transactions they were, the revenue transaction, and they would be taken to the Treasury for reconciliation.
Now, in this case, again, just to look at the circumstances of a report, and we'll don't need to get too much into the detail. If you look at 2030, and in particular on paragraphs 2.4 and 2.8, I'm just going to summarize it. Essentially, it comes to this, that on November 16th, 2015, the Internal Audit Department received information from the Ministry of Finance in relation to an allegation of missing revenue at Her Majesty's Customs. And what was reported was that, and this was by the Commissioner of Customs, was that a preliminary investigation had been conducted. And that had revealed that a customer had presented receipts substantiating payments for import duties at a particular location, but no corresponding revenue was deposited. And so, and we look at see this at 3.1, an audit team from the Internal Audit Department was put in place, and to ascertain whether the revenue that has been identified as missing had indeed not been deposited. And what was noted was that because of the sensitivity of the situation, what the audit team limited itself to was interview with management at the Treasury Department, review of their revenue reports for January to June 2015, and receipt distribution logbooks to determine if the revenue that was paid, as indicated on the customer's receipt, was deposited on the government's accounts.
Correct, sir.
And so what the customer had presented was effectively receipts from a receipt book saying effectively, I have paid these. And the question was whether those payments had actually been received by the Treasury, ultimately, wasn't it? If you go to 3.2 on page 2031,
Correct, sir.
what the review conducted by the Internal Audit Department revealed was that no revenue in the amounts detailed on the customer's receipts had in fact been deposited. That
is correct, sir.
And so the loss, we can see at the bottom of the table at page 5, the loss therefore was $264,885.33. Is that right?
That is correct.
If you look across at the next page at 3.4, as part of the investigation by the Internal Audit Department, the receipt books, the serial numbers on the receipts presented were matched to a manual receipt book that had been issued, but it wasn't it was to a receipt book that was issued to other locations. We see that in the table at 3.3, rather than to the location at which the customer's transactions were said to have taken place.
That is correct.
And then what's also noted at 3.5 was that there were two aspects of the receipt. Firstly, that there an electronic version of the distribution of receipt books was presented by the Treasury Department, showed receipt books issued from the years 2011 to 2015, but didn't contain any signatures as to who received the books. And also at 3.6, that the receipts didn't detail the method of payment used by the customer, but following discussions with the Ministry of Finance, the report back was that the method of payment used was cash.
That is correct, sir.
That was as far as the investigation could be taken, given that as you pointed out in the audit report, there were limitations on what the department could do. I just want to take you to the conclusion. At 4.1, what's said is there are other issues surrounding this matter that begs the question of whether other criminal activities are also being perpetrated. Now, can I ask you just to be careful, not to name either any individual by name or any company by name, but where the report is referring to other issues surrounding this matter, what did the audit team have in mind?
I can't recall at this stage, but I'm sure that the work papers would identify what those other matters would have been.
What is said is that best practice would dictate that businesses conducting transactions of such magnitude, and we've looked at the amounts involved, which came to $264,000, would opt to make payment by using some banking instrument, such as a money order or a banker's check, or for an established company, a company check. But in this case, the importer chose to regularly pay for his import charges in a manner contrary to this practice. Therefore, this method of payment raises some red flags. For an auditor, where large payments are being made in cash for a commercial transaction, is that always a red flag?
Based on the services that you're paying for, yes. It has to identify with the type of service you're paying for. And given the amount, of course, it would raise a red flag, yes.
Now, what's said at 4.2 is based on our preliminary investigations. This office has concluded that there exists a high probability that fraud has been perpetrated at Her Majesty's Customs, and this fraud has possibly resulted in the government of Virgin Islands suffering a financial loss of approximately $265,000. As stated in the Commissioner of Customs report, on the advice of the Attorney General, we recommend that the matter be submitted to the competent and appropriate authority for further investigation. Now in this case, can you remember, Mrs. Corea, what further steps were taken after this?
From the top of my head, no, sir, but I'm trying to read the document to verify.
If you want a moment to look at it, please take it.
Thank you. I don't see any further action on our behalf taken on this matter, other than what it says in the conclusion.
If you look back at the beginning of the document, which is at 2029, this is a November 2015 report. What's set out at the beginning of the document of 2029 is effectively section 16 and what the requirements of section 16 are. And if you look at 1.3, or 1.2 refers to the director informing a permanent secretary, auditor general and the committee about his or her findings. 1.3 says that where the director reports to the committee an irregularity or fraud concerning government asset or property of a public authority may have occurred, the committee could then inform a minister. And the final thing, 1.4, is that where there is what appears to be an offence against any law, the committee shall submit all information submitted to it by the director to the Commissioner of Police for investigation. In this case, do you remember whether there was any of those steps were taken?
I'm trying to remember, but I cannot recall. Based on the correspondence though, dated December 1st, 2015, it did make mention to have the competent authorities outside of the internal audit department to look at the matter. But I can't recall right now what actually took place after our initial review. I cannot recall right now.
In circumstances like this, where in this case, Customs did the initial investigation, then the internal audit department was brought in essentially to review and confirm the position. Where you've got that overlap, is it possible that it might have been left to Customs to refer it to the competent authorities, or would it be a matter that would sit with the internal auditor or the Ministry of Finance as the line manager of Customs?
It can take the channel of either authority. The fact that it was brought to our attention from the department placed it in our hands at the end of the day. So we also had a responsibility to follow what is outlined in our act, to transfer it to the proper authorities. As I said, as of right now, I cannot recall exactly if that was done, but I know it is mentioned in the correspondence of December 4th, 2015, saying that that is a course that it should take.
Yes.
But as of right now, I cannot recall if that was actually done.
I don't think we can take it any further today, but perhaps is that something that we could leave with you, and perhaps you could check your department's records at some point just to confirm whether there were further steps taken.
I can certainly do that, so.
Thank you. Can I take you to another report? And I think we're going back to we're going to go back to the part 3 bundle. And page 2334, please.
Two, 3, 3, 4, you said?
Please. In fact, if you look at 2332, actually.
I have it.
It should be an audit report that's dated December 2020, and it's Her Majesty's Customs, courier clearance operations and partial payment programs.
Correct.
If you turn to 2334, you'll come to the introduction.
Correct.
If you look at the fourth paragraph down, there's a neat summary there of the two areas that were the subject of the audit exercise. And they are identified as the partial payments program and the courier clearance operations. And the introduction says this about partial payments program. It focused on the administration of a program whereby customers who desire to import large valued items are allowed to make installment payments over a certain period of time for the duties calculated on these items. The customer applies to the Commissioner of Customs, who in turn either approves or denies the request. The Deputy Commissioner and Assistant Commissioners can also approve requests for partial payment. Then over the approved installment payment period, the customer's account is managed until all calculated duties have been paid in full. The second area deals with the facilitation of trade for courier companies operating in the territory. Currently, there are numerous courier companies operating in the BVI that provide courier services through air and sea shipments. These courier companies are required to register with Her Majesty's Customs in order to conduct business. Several sections of the Customs Management and Duties Act 2010 and its amendments govern the administration of these operations. Now, the way, as we'll see, that the audit was done was that in 2019, the audit department reported on the partial payments part of it. So it was almost a split audit. It was the 2020 exercise was looking at the courier clearance operations. So if we take partial payments first, and if we go to 2360, please. This is the first page, in effect, of the audit report on partial payments. So it's dated October the 7th, 2019. And if you go to 2361, sorry, go back to 2360. There's just a bit I wish to draw your attention to. At the bottom, in terms of background, if we pick it up on the second sentence, what's recorded there by the audit team is this: over the years, HM Customs has approved requests from importers to make payments of the assessed custom duties through partial payments on large valued items. Initially, this courtesy was only afforded to government employees, as repayment could be easily managed through salary deductions. However, the program has evolved and now includes any importer who is approved by the Commissioner or an authorized officer to make custom duty payments through partial, open brackets, installment, close brackets, payments. A down payment on the assessed duty is required, and the balance is to be paid in installment payments over a defined period. Once approval is given, an agreement is to be entered into which sets out the terms and conditions governing the payment of the outstanding duty for the particularly approved T12. A file is created for the importer, and accounts receivable record is set up within the JDE system to manage repayment. So the JDE system is the JD Edwards system, is that right?
That is correct, sir.
Could you just clarify for the Commissioner, a T-12, what is that?
A T12 is a declaration form that is used to clear imported goods.
if you go to facts and findings, which is on page 2631, what's noted is that Customs has operated the partial payment program with various levels of success in terms of collecting outstanding revenue. And as of June the 1st, 2019,
Mr. Rawa, where are you? Sorry.
1, please. If you go to 2361, please, Mrs. Corea.
Okay.
And at the top, you'll see the heading facts and figures.
Okay.
Finding.
Okay.
And the point is made that the Customs has operated the system with varying success. As of June the 1st, 2019, the program had $490,145.60 outstanding. And that was based on information provided from HM Customs. And that was a period, it seems, that spanned 1996 to 2019. Is that right?
That is correct.
What the report then goes on to do is to identify a number of issues with the partial payments programs. And I just want to kind of summarize those. So if we look at one, the first point was made that there were no policies or procedures in place to guide the administration of the system, leaving, therefore, it's poorly managed and it's at the discretion of the officer managing the file for the importer. Does that mean that where you have no policies and guidance, you can get inconsistent decision?
That is correct, sir.
And that links, doesn't it, to the point that's made by the audit team at 2, that the approval of requests for customs duties to be made via partial payment lacks appropriate controls to guide approvers in arriving at a decision. The audit found that sufficient due diligence is not conducted or sufficient information collected to inform customs on the importer's ability to pay when deciding on requests. And so what there wasn't for those officers who are authorized to make the decision is any guidance as to how they should apply their discretion.
There's none.
Decisions were in effect made on a somewhat arbitrary basis, is that right?
Yes, and on a case-by-case basis as well.
Now you illustrate that with your point 3, which goes to a lack of due diligence, because and again, the audit team undertook a sample process. You found an employee who'd left the government's employ in 2017, defaulting on significant outstanding balances for both vehicle and personal loans, but was then approved for a partial payment in 2019, of which only the down payment was made. And that speaks, doesn't it, to a lack of checks and balance in the system.
That is correct.
And you make a similar point at point 4, that partial payments were approved for multiple T12s for the same importer, even though the importer was delinquent in his payments on a previous agreement. So the fact that the importer was behind on payments or hadn't made payments under a previous agreement didn't seem to stop them having a new agreement for partial payments. Is that how we should understand it?
Yes, sir, that's how it is.
At point 5, you also say that, or what the audit revealed, was that Customs was collecting inadequate information on importers that had been approved to make partial payments. And so the department, you note, usually collects a telephone number and only recently began collecting forms of identification. And the problem there is this, isn't it? It makes it very difficult for Customs to monitor whether someone is complying with the payment program, and also to try and enforce non-payment when it becomes a problem.
That is correct, sir.
the audit also noted that the partial payments agreements seem to vary in their content, and some of them were poorly drafted, which meant that if there was a legal claim, it might be difficult to enforce the claim.
That is correct.
You also noted that agreements are not collateralized. Now that's at 7 on 2362. Could you just help the Commissioner just with understanding what is meant by collateralized?
So you have a request for a partial payment, and the information would be provided on a T12. Depending on what the goods are, they would have varying values. Therefore, if you were to collateralize them, you will have what the estimated value of all the goods are listed, and the agreement would incorporate those payments, those values on the partial payment document.
Thank you. The other point that, and this is at 8, that the audit revealed that there were cases where partial payments were initiated without even a signed agreement being obtained, which would mean that if someone defaulted, there would be no documentation to show that an agreement had been entered into in the first place. Do you see that?
That is the case.
And so the agreements were, the agreements when they were there were poorly drafted, poorly executed, which would have made it much harder for customs to recover monies.
That is correct.
If you look at 9, which is on 2363, what the audit highlighted was a lack of adequate monitoring and enforcement, which it was said stemmed from a number of factors, and those are all listed out in the report. But firstly, no policies or procedures to guide monitoring and enforcement. Secondly, that there was a failure to monitor files on a consistent basis, which means that accounts would fall into delinquency. Thirdly, that given some of the accounts were now so old, there would be actual difficulty in recovering sums of money. And what you note, and this is at the bottom of the page, was that an opinion had been obtained from the Attorney General, which was to the effect that government may be statute barred from recovering approximately $265,000. So when we looked at what the auditor have identified was that $490,000 were outstanding, and it would appear that the majority of that would no longer be recoverable.
Based on the years, that is correct.
And what was also a problem with monitoring, we see at 2364D, was that government employees who had agreements for partial payment left the service with unpaid balances.
That is correct.
Also, what was noted was that for some government officers, the basis of repayment was differed. So there wasn't a consistent approach to government officers, and that's at E, because some government officers would pay back under the partial payment program by salary deductions, whereas others were allowed to make direct payment to the Customs Department. And that second option weakens the control, according to the auditor, that the department has over recovery. Is that right?
That is correct.
The other two points that examples that you gave for why there was inadequate monitoring and enforcement are firstly that repayment plans were not being adhered to, that's at F, and then at G, which is at 2365, it was noted that it was found that outstanding balances for custom duties for deceased persons are still being carried as outstanding amounts, even though the chance of collection is nil, as in most instances the agreements do not make any outstanding balance a part of the decedent estate. And so, bringing that together, Mr. Corea, was the effect that because of the way the system had been run, there was a significant outstanding balance, but most of it, or a good part of it, was no longer recoverable, and a good part of it included sums that because the person had died were never going to be recoverable.
That is correct.
Now, if you go to point 10 on 2365, the audit noted that there were no performance measures to assess how the program was operating. So this goes back to points that have been made in other audits, doesn't it? There's nothing in place to show whether your system is actually effective because you don't measure whether it's working or not.
That is correct, sir.
And taking you away from this, but sort of stepping back as the auditor role, is that something that as an auditor you see time and time again? The systems that are put in place do not include measures by which performance is benchmarked.
That is true. In a lot of instances, yes.
And presumably in those instances, the internal audit department is raising this as an issue, the importance of having performance measurements.
Yes, that is true. The only way you can determine if you're effective and you're achieving your objectives is to have performance measures in place.
Again, you're away from the detail, but do you think that's
I'm sorry, Mr. Could you repeat that again? There's a little sound overlap.
Sorry, certainly, Mr. Kazdan. What I was saying to Mrs. Corea is to again take you back from the detail and to the more general question of the benefit of performance indicators. You've confirmed that the internal audit department will raise the need for performance indicators with public authorities. Do you think that that's a message that has sunk in, the importance of having performance indicators?
Across the board, no.
Is it still, for the internal audit department, a work in progress?
It still is, sir, yes.
What you did, and we see this at 2365, was attempt to look at some performance measures using the information available to try and assess how the operation, the program was operating. And if we look at there is a table on page 2365 which shows the outcome of that. And so the first performance measure was default rate. And the description of that was the percentage of all outstanding payments that have been outstanding after a prolonged period of missed payments. And you took 6 months. So how many, the question was how many payments is outstanding after 6 months of prolonged non-payment, is that right?
That is correct, sir.
And the calculation of that was 83%. The next performance measure that the audit adopted was to ask for the longest outstanding period. And that the longest outstanding period was 14 years and 6 months.
That is correct.
And that is taking it back pretty much to the start of the scheme, isn't it?
That is correct, sir.
The shortest outstanding period was the next measure. and that was reported as 1 month. And then the next measure that you looked at was the largest outstanding amount waiting to be collected, which was $22,647.99.
That is correct.
Now, the last one was is recorded as a measure as active customer accounts per collection officer. And its description is the ratio of customer accounts to employee managing the accounts. And you found that the ratio was 25:2. So each employee was managing 25 files. Now, why was this a useful performance measure? And what did the ratio indicate to you as an auditor?
One, the resourcefulness of actually monitoring the payments. And two, if you don't have persons in place to monitor the payments that are being collected, chances are they will become uncollected because there is no one filling the gap between contacting the customer to verify and to inform the customer that payments are due. So there's a gap that needs to be filled with that ratio.
The last measure that I want to draw your attention to, Mrs. Corea, was at 2366. And this was to look at accounts, it's the last one in the table, accounts outstanding 61 or more days as of the 31st of August 2019. So it's customer accounts outstanding 90 days or more. And you found 47 accounts outstanding. So that was the greater majority of accounts had been outstanding for a significant period of 90 days or more. Is that right?
That is correct, sir.
Now, you made recommendations, and we see those at page 2366, and they fall into effectively two camps. The first was this: given the high default rate and the lack of a discernible business or economic value, its partial payment program be discontinued. And you then recommended getting advice from the Attorney General's chambers as to how easy it would be to recover delinquent balances. I just wanted to ask this: why was it that the audit department came to the conclusion that it was appropriate to recommend that the program be discontinued?
Because the program was not functioning and you are only adding more persons to a process that was not being monitored, and the possibility of not collecting the funds were at risk. So it was determined that it should be canceled.
Did you, we see this if I take you to the conclusion. I mean, the conclusion was that, which is at page 2367, is that the system lacked appropriate and effective controls. It was void of a strict management structure and system to ensure compliance of importers, some of them being government employees and custom officers. As a result, duties under the program had been in arrears for lengthy periods without any definitive actions taken to collect the debt. And what you noted was that the program, as currently structured and managed, serves more of a social interest and detracts from the revenue collection mandate of the department. As a result, significant government revenue is at risk of being lost. So would it be fair to say that the internal audit department didn't see this as a viable program at all?
It can be a viable program, yes, but if the controls and the processes are not in place, then it detracts from even becoming a viable program.
and left as it was, it was not viable. It wasn't delivering value for money or transparency or accountability, was it?
No, it was not.
I said that your recommendations fell into sort of two parts. What you did do was, as the internal audit department, was to say that in the event that it was determined that the program serves a legitimate business or service delivery objective for the government of Virgin Islands, there were a number of recommendations that were necessary to strengthen the program. And those were, and I'll summarize them, a need to put in proper procedures and policies, need to have guidelines to determine a proper repayment system, the use of a draft agreement provided by the Attorney General's chambers, that any public officer wanting to use the system should have payments deducted through salary reductions, that there was a need to decide how much would have to be written off as uncollectible, the need to develop relevant performance indicators, and then that you recommended an administration fee be adopted. Now, if we look at 2389, this is part of the management response from customs. It's the beginning of it, and it's that part that relates to the partial payment program. And it seems that in terms of all of your recommendations, or the recommendations of the Internal Audit Department, Customs agreed with all of them, save for the last one, which was about the administration fee, because it was said that this was done by the response was it had to be a matter for the financial secretary, whether there was an administration fee or not. You responded to that.
Mr. Roberts?
Yes?
The page you're reading is 2389, you said?
Yes, 2389.
I'm missing one page, just 1 minute. Okay, go ahead.
But I wanted to take you to the management response, but because this is an example of where the public authority agreed with all of your recommendations. So 2389 is the first one, and that I think that what the agreement came down to was that they did not agree to scrap the system, but they agreed to take steps to adopt your other recommendations, so that to improve the system. The only one that was disagreed with, we find at 2396, which is that the fee, administration fee that your department recommended, the response to that was that it had to be a decision for the financial secretary. But again, for completeness, if we go to 2405, the director's response to that was that whilst it's a matter for the financial secretary to submit the request to cabinet, the department, and that is the customs department, should take the lead in beginning the process so that it could reach cabinet for review. Now, that's the sort of timeline that was given by customs would take us into the end of the first quarter of 2021. having made those recommendations and having received that response and a timeline, do you know if any changes have been put in place to the partial payment program?
No, I don't know if anything has been put in place, but I do know that they have been contacting us to get information with regards to partial payment regarding our report in terms of implementation. But I'm not certain if they have already started the implementation process with regards to that.
Thank you. Commissioner, could I ask we take perhaps give Mrs. Corea and the stenographer 5 minutes now before I'll deal with, the next topic will be courier clearance processes.
Yes.
So I'll go on to that.
Yes, thank you, Mr. Rowett. 5 minutes. Thank you. Thank you. Yes, Mr. Rowett, thank you.
Thank you, Mrs. Corea. Can I take you back? It's in the same report, but now to page 2336, please. As I indicated, there were two aspects to this audit. We've looked at partial payments program, and the second aspect was in relation to facilities of trade for courier companies. And if we look at 336, so this was the 2020 aspect of the audit.
Correct.
There is an explanation there, which I think is helpful to put into the record of courier trader processing. And this is under findings and recommendations and courier trader declaration processing general findings. What's said there is this: custom trader declarations are used by importers or licensed custom brokers acting on their behalf to clear imported goods from customs control into the commerce, open brackets, home consumption, close brackets, or into a licensed warehouse. Generally, all goods imported into the British Virgin Islands are liable for duties and taxes unless an exemption or concession applies. An import trader declaration is a statement made by the importer, open brackets, owner of the goods, close brackets, or their agent, open brackets, licensed customs broker, close brackets, to provide information about the goods being imported. There are three specific types of declaration an importer uses when importing cargo into the territory. An import trader declaration used for all cargo being directly imported into the territory. A deposit trader declaration used for the importation cargo under the following circumstances: when at the time of importation sufficient information is not available to make a complete and true declaration, or two, for perishable cargo or cargo with time constraints. Importers are, however, at all times required to make a complete and true declaration, even when utilizing this type of declaration. And the third one is an adjustment trader declaration, which is needed once you have declared cargo using a deposit trader declaration in order to settle and clear the deposit. What's also said is that in the BVI, there has been the emergence of a significant amount of imports through the use of courier services, which are third parties. And you give some examples of courier services. But the report then continues with the proliferation of the use of this method of importation. HM Customs has implemented processing procedures to facilitate the processing of imports through couriers. The audit found deficiencies in the processing of imports through these courier services. Now, part of that, or the deficiencies that you found, a number of those was in relation to what's known as the Customs Automated Processing Systems, or CAPS. We will find a summary of what CAPS is about at page 2346. Perhaps if we go to that first so we can orientate ourselves. At the bottom of 2346, under the heading Customs Automated Processing System, or CAPS, what the report recorded was this: on November 1st, 2016, HM Customs rolled out the implementation of CAPS, which allowed all trader declarations to be completed and submitted electronically to the Department for Processing. The implementation of CAPS was to facilitate the collection of accurate trade data, reduce the amount of time spent at a customs port, and expedite the clearance process of goods, efficiency in data mining for all stakeholders, and risk profiling of non-compliant importers. Furthermore, the implementation of CAPS also assists in the development of accurate trade statistics in the classification of goods. The collection of trade statistics allows the executive branch of government to make policy decisions on imports and/or export, as incorrect classification results in flawed government policy. All couriers are required to utilize CAPS to submit their declarations. Due to the evolving business structure of couriers' operations, particularly at the TB Letsum International Airport, the department has initiated standing deposit arrangements with some couriers in an effort to facilitate this business model. As a result, some couriers are allowed to submit a deposit declaration which is charged against the standing deposit, and within 15 days of the cargo being released, an adjustment declaration must be submitted along with the requisite payment. I'm going to pause there. What I'd like to just also direct your attention to, please, Mrs. Corea, is if we go to 2335. Under audit limitation, the report noted that CAPS utilized in the processing of courier trader declarations was utilized in reviewing couriers' deposits and adjustment declarations. However, during the course of the audit exercise, the auditors were informed that customs officers have not been utilizing CAPS in the manner in which it should be used, and as such, the system contains a number of trader declarations that have possibly been processed, open brackets, adjustment declaration prepared and subsequent payment made, but for which no entry clearing the deposit declaration was entered into the system. This has occurred due to officers accepting and processing manual adjustment declarations without entering the information in CAPS thereafter. So just to understand that, does that mean that in approaching the CAPS system, you had to do so with a degree of caution as to the accuracy of the records it held?
That is correct. There was a question of the integrity of the information that it was actually providing.
If I take you now to 2337 and we start just, I don't want to focus on recommendations, but firstly, the deficiencies that the audit identified. If we go to 237 and you look at 1, what you could not establish as part of the audit was what written agreements and bonding mechanisms, and that means insurance, banking arrangements, etc., exists for all couriers allowed to operate under the standing deposit schemes. You found agreements and supporting documents for only 2 couriers, and then went on to say that although standing deposits were established for these couriers, the audit found that the department had not put in place adequate controls to monitor the balances of these deposit accounts. So essentially, in relation to the couriers themselves, it was not possible for all of them to find the written arrangements in place.
That is correct.
And in relation to the 2 where you did find written arrangements, the system that they had, which was that they could essentially work against a standing deposit, was not effective because the balance of those deposits was actually not being monitored properly.
That is correct, sir.
If you go to 2, you note this, or the audit does. The department has not established documented guidelines for the processing of declarations. As a result, there is no consistent approach to the processing of declarations within CAPS, from officer to officer and from station to station. Furthermore, officers are allowed to select on a discretionary basis which declaration they process. The audit is concerned that this situation exposes the department to 2 significant risks. And those 2 are A, the situation promotes an environment for inappropriate relationships to be fostered, where officers can offer preferential treatment to importers in the processing of their declaration, which may include the offer of gifts and/or payments. And B, given that it is alleged that a number of customs officers provide brokerage services, whether legitimately or illegitimately as a private interest for supplemental income, poses a significant conflict in that officers may be reviewing and releasing declarations for which they had a direct involvement in the preparation, or at least may have significant influence in the processing of such declarations. Absent of appropriate controls to monitor and manage and minimize this conflict, the current process is ripe for fraud. Now, just breaking this down, if I go back to 2, no consistent approach to the processing of declarations within CAPS from officer to officer and station to station. Does that not go back to your point about integrity of information? If there's no consistent process, either from locations or between individual officers, there is a serious question mark over the information that is held in CAPS, isn't there?
That is correct, sir.
And that frustrates not only the auditor, but it frustrates the department in terms of understanding how the system is being utilized. Would you agree?
That can be the case as well.
Now, the 2 risks that you identify at 2 is an environment for inappropriate relationships to be fostered. Did I take it from that, and correct me if I'm wrong, that the conclusion of the auditors was that on the way that the absence of guidelines for processing of declarations meant that that was the environment that was in existence?
That is correct. Mm-hmm.
And did you see or receive as part of the audit any evidence of inappropriate relationships?
No, sir.
Would you, I mean, but the point is that it's right for that kind of situation, isn't it?
It is so.
And it would only be remedied by the Customs Department taking swift action.
That is correct, sir.
The second risk is the customs officers providing brokerage services, and that risk of significant conflict. Now, brokerage services would be them acting as an agent for an importer, is that right?
That is correct.
Now, I'd like to just break that down a bit, because the audit report says providing brokerage services, whether legitimately or illegitimately. Now, in what circumstances could a customs officer legitimately provide a brokerage service?
If they have the authorization to do so, which is if they have an approved trade license to do so, then they can legitimately.
And illegitimately would be if they haven't either got an approved trade license and or declared that activity to the Customs Department.
That is correct.
And you've pointed to the significant risk that poses in terms of a conflict. Were you aware, or was the audit team during this audit, was it aware that there were customs officers that were providing brokerage services?
There was an assumption that was raised in terms of officers doing custom brokerage, yes.
And sorry to cut, please finish.
And before the investigator to find out if that was in case a fact.
Your voice dropped a little, Mrs. Corea. Could you just repeat that again, please?
I said there was an assumption that was made that, yes, there perhaps might have been some officers doing brokerage work. And in verifying, we investigated further to ensure that was a fact. And it was.
So the audit established that there are officers providing brokerage services in the Customs Department?
Correct, sir.
And did the audits establish that there were officers who were providing those services illegitimately?
Illegitimately, possibly not making the department aware. However, they have had approved trade licenses to do the activity.
And so where the difficulty for them arises is that they hadn't made the department aware that they had that side job, if you like.
That is correct, and that creates a conflict of interest.
And it's a particularly important conflict of interest because if they haven't declared it to the customs department, nobody can there's nobody independent to assess whether there is in fact a conflict of interest or not.
Correct.
There is no good reason, is there, for a customs officer not to let the customs department know that they are offering a brokerage service for supplemental income?
No, sir.
And in circumstances where they do that, and they don't let the customs department know they're doing that, it raises an immediate suspicion, doesn't it?
Yes, sir.
As part of the audit, were the auditors able to confirm whether there were systems in place to identify potential conflict arising out of officers offering brokerage services?
Yes, there was.
And did the auditors form a view about the adequacy of those systems?
Yes, we did.
And what was the conclusion about the adequacy of those systems?
The systems needed to be reviewed to ensure that just as it said in point B, that these persons were not actually doing the declarations and releasing the declarations. So there was a need for the system to be reviewed to assess who was doing what.
During the course of the audit, did the auditors or did the audit team become aware of customs officers offering brokerage services but using other people's trade licenses?
Not that I can recall.
When you say that you can't recall, does that mean that it's possible that information was uncovered during the course of the audit?
Well, I don't recall remembering anyone using somebody else's trade license, perhaps using their own.
Have you, otherwise than in the course of this audit, ever come across that situation? Customs officers offering brokerage services but under somebody else's trade license?
No.
Thank you. Could you, if you just turn up page 2376, please. This is part of the management response to the recommendations that were made in this audit. And it flows on from what we were just looking at, Mrs. Corea, but the recommendation that the audit team made was, if I look at the second sentence, it's recommended department develops internal processing guidelines for its officers in administering their duties as it relates to the processing trader declarations and the clearance of imports. These guidelines should consider how each type of declaration is to be processed and ensure that appropriate processing controls are in place, such as segregation of duties, user accessibility, considering roles and responsibilities, etc. The response of the customs department was to say, we agree to the findings stated. We're confident that the above will correct concerns in this section. And then it continues in these words: although the department does not succumb to allegations, we are aware of the temptations of participating in illegitimate, open brackets, actions that may bring the government into disrepute, close bracket, brokerage services. This was obviously a management response addressed to the internal audit department. But I just wanted to ask you this: what did you understand by the phrase, the department does not succumb to allegations?
I can recall at one point having a discussion in the exit meeting about the possibility of officers doing brokerage that maybe the department was not aware of. And at that point, we indicated that there should be a segregation of duties for what they are doing. And because we made that comment, we were told that that's an allegation.
Now, when you refer to an exit meeting, at what stage in the process does the exit meeting happen?
Well, once we have completed our draft report, we have what is called an exit conference, which is meeting with the client, going through the findings of the report, identifying what our recommendations are. And then in that meeting, the client, which would be the department head, would be responsible for clarifying any information that was inaccurately stated, and we would make any amendments as necessary. So it was having a collaboration with the department or with the client to effect the accuracy of the draft report.
And by the time that you came to that exit meeting, from the perspective of the audit team, you knew as a fact that customs officers were offering brokerage services. That's right, isn't it?
That's right.
And that the way that CAPS was being operated had a significant risk of, gave rise to a significant risk of conflict.
That is correct.
And from the perspective of the customs department, they saw it as or the risk that some officers may be illegitimately offering brokerage services as no more than an allegation.
That is correct.
If we go please now to 2338. And this is, if you look at number 3, this is the third deficiency that is identified. And it's said to be based on research. Does that mean that it's based on research undertaken by the team, by your team during the course of the audit?
That is correct, sir.
And what it comes down to is this, is that because CAPS was not fully functioning, there was no system in place to ensure that deposit accounts had sufficient balances.
That is correct.
And so the risk there was that someone couldn't actually pay the duty that they were bound to pay. Is that right?
Correct.
If you look at 4 now, the next deficiency that's highlighted is that because of a lack of adequate monitoring, the department couldn't, and that's the customs department, could not provide the current standing balances standing deposit balances for the couriers participating in the scheme, although this is information that should be considered in determining whether a declaration will be released against the deposit or immediate payment would have to be made. And again, is that just demonstrating that the CAP system was just not being used properly at all?
I suppose so, sir.
Well, it's important that we have your view, Mrs. Corea. What do you think it shows as a deficiency?
Yes, yes, it shows that the CAPS program was not being used as intended.
If you go to the next page, the fifth issue that was identified as a deficiency was that deposit declarations were being used in a manner which circumvented the requirement for the proper classification of imports, and in a manner that fails to adequately identify and assess the government's risk exposure. And you conclude that the government's operational objectives for the implementation of CAPS are not being achieved while being exposed to revenues. Does that mean that what the audit team was concluding was that, firstly, CAPS was not being utilized in the way that it was intended, and secondly, the consequence was that revenues were not being collected, so increasing government's risk?
There was a potential that the risk was not being collected, because if you use the deposit declaration, you can actually circumvent the system in what revenue is actually paid. And when we get further into the report, you will realize how that can be done.
Perhaps if we pick it up at that point, if when we get to that point in the report, if you could just draw it to the Commissioner's attention, that would be very helpful, Mrs. Corea.
Okay, I will.
Number 6, and I'm trying to summarize these, so if I over summarize, do stop us and clarify. But number 6 is the point that the audit found that freight charges on deposit declarations are significantly understated in comparison to the same charge on the corresponding adjustment declaration, therefore significantly reducing the amounts that are charged against the standing deposits. Could you just develop that a little for the Commissioner, please? Firstly, how was this being done, and what was the consequence?
Okay, let's go back to number 5, because I think that's the point I actually was raising before. When you have a deposit declaration being done, it's actually to facilitate the import goods to be released before you actually make the payment, because you're supposed to be having you're supposed to have a standing deposit in place in order to submit a deposit declaration. You with me?
Yeah.
Once a deposit declaration is made and the goods are released, there's what you call an adjustment declaration. The adjustment declaration is submitted against the deposit declaration, which would actually identify how much charges are to be placed against the goods, and that is when payment would be made on the payments. A payment summary would be executed from that adjustment declaration, and that's on what basis the payment would be made. So it's like marrying 2 documents in order to identify what the actual payment amount should be. So once you get that adjustment submitted against the deposit declaration, then you would know exactly how much money you're supposed to pay. At that time, the goods are already released, remember? So you're actually paying on the back end and not when you actually have the goods released to you, if you understand.
You're catching up with the payment. You've
Correct.
already, you just catch up with the payment.
Correct. So that's what number 5 is basically trying to identify. And that's why it says adjustment declarations are also submitted and processed in the same manner. Consequently, government's operational objectives for the implementation of caps are not being achieved while being exposed to significant risk of revenues. So you've brought in your goods, you've done a deposit declaration, the goods are released, you come and you put your adjustment declaration in against your deposit declaration. That's when you would make your payments, and that's when the government would receive its revenue.
So how does that then link to 6?
Well, 6 is illustrated, isn't it, by table 1 over the page, Mrs. Corea?
It is.
I mean, and that shows that the difference between the initial declaration, just in aggregate $47,000, and the adjustment $224,000. There was a big difference between those.
That is correct, sir.
And the difference, which in that case was about $170,000, that was at risk in the sense that the goods were already in the territory.
That is correct.
If you go to 7, which is at 2340, and we can look at 7 and 8 together, but the point that's made at 7 is that customs has 2 roles. Firstly, it's revenue generating, but also it's about protecting society by preventing restricted and prohibited goods from entering the Virgin Islands. And the point that's made at 7 is that there was insufficient resources at Beef Island, which meant that officers were prioritizing trade over border protection, which therefore increased the risk of illegal items coming into the territory. And then at 8, because of the short turnaround time for the submission of declarations and the declaration of cargo, meant that there wasn't adequate time for reviewing the declarations. And so both those make it, again, increase the risk to government, don't they?
That is correct, sir.
At 9, which is at 2342, what's picked up by the audit team is that when a courier service collects the cargo, it has to present additional supporting documentation in the form of various invoices, and that you found a lack of standards and guidelines relating to the invoices. And so, for example, invoices were of a poor quality, sometimes written in foreign languages, sometimes illegible, which again means that it makes it even harder to process the declaration through, doesn't it?
That is correct, sir.
And then at 10, deficiency 10 points to inadequate record keeping in the Customs Department itself. So not only were couriers required to submit documentation electronically, they were also required to submit them physically, but there were no inadequate systems to actually manage the physical documents.
That is correct, sir.
And what you also say is that not all documents are stored electronically within CAPS, which again, that undermines the usability of CAPS as a system, doesn't it?
Yes, sir, that is a fact.
Which we go to page 2343 rather. If you look at number 11, what it records there is that the audit found a general lack of understanding of the requirements of processing courier entries in CAPS, or unwillingness by seasoned customs officers to adapt to changes in service delivery. Does that mean that you more, I suppose, long-serving customs officers were reluctant to change their practices to use caps?
That is correct.
And generally, was the result of the audit that the system was being poorly used by the Customs Department in 2020?
That is correct, sir.
I don't need to go to it because that's a point that's made in 12, but if we go to look at 13, what's noted that one of the implementation objectives of CAPS was to facilitate reporting. The audit found that the reporting suite within the software is currently non-functional, and that the department was in the process of procuring an additional reporting program. But the audit then noted that based on the poor use of CAPS, significant amount of missing data, and the acknowledgement from HM Customs personnel about the reliability of the data currently in CAPS, the additional expenditure to obtain reports will be of little benefit. Is the sort of way of summarizing what was happening with the CAP system in 2020 was that, in a way, the Customs Department would have to draw a line in the sand and start again with CAPS because you couldn't trust the integrity of the information that it held?
In most regards, so yes.
If you go to 2344, this is now about the processing of courier declarations. And what's noted is that the declarations are processed at two locations. Firstly, within the CAPS unit, which is called centralized processing, and then at the port of entry where the cargo enters the territory. Now, what's said is that when centralized processing was being conducted, there was adequate segregation of duties within the process. I'm pausing there. Can you just expand on what's meant by adequate segregation of duties and explain why that's important, please?
So in the CAP system, in the whole process of cargo declaration, there are different steps from the time you declare an import until when the importer actually receives the cargo. And I'm talking about the regular importation declaration. So you have the importer declaring that these goods are coming into the territory. They have to provide a declaration. The declaration is then accepted and reviewed. There's a review process. Once it's reviewed, there's also a release process. And then once it's released, there's a payment process. So at the different stages, there would be a segregation of duties as opposed to one officer dealing with the whole entire process. So within the CAP system, those different functionalities were separated.
And from an auditor's point of view, separating functionalities is a good thing.
It is.
And that contrasts with the process at the when you say it's the port of entry when the cargo enters the territory. So what you seem to identify is that there was firstly that when the goods are coming in physically at the port of entry, there was no updating of CAPs. There was a disconnect between the operations of the CAP unit and at the port of entry. Courier declarations, you say, are now being processed at the port of entry, but that removes the key control of segregation of duties. So shifting from the CAPS unit to the port of entry introduced risk because it got rid of segregation of duties. Is that how we should understand it?
Yes, sir. And if while we're at this stage, if you want to look at page 2353, number 9, it also gives you an outline as to when the entry begins, that it's validated, it's reviewed, and then it's released. So number 9 would give you all those different steps in the CAPS processing system.
But if you're so in a CAPS process, you would have segregation of duties. When you're doing the system physically at the port of entry,
it's different.
You don't have that, which means, I think, as the point that's made at 14 is that you don't allow for proper verification and validation of the cargo that's been released.
Correct, sir.
15 on the same page, and we're going back to what you were speaking of a few moments ago, Mrs. Corea, about the difference between the deposit declaration and the adjustment declaration. What's the deposit declaration? If you file that as an importer, well, it means that the cargo is released to you, and you're then expected to file your adjustment declaration, at which point you make the payment.
That is correct, sir.
What the audit appears to have found is that there was a very low compliance rate with that second requirement, with the result that there's a risk of payments going uncollected, isn't there?
Yes, sir.
I think at the bottom of that, the last part of that deficiency, the audit had considered some adjustment payment summaries and found that in terms of confirmation level, it was only 18%.
That is correct, sir.
So that's confirming it's an 18% confirmation rate of payment actually been made on an adjustment declaration. Is that right?
That is correct, sir.
I will jump ahead and just take you to 17 on 2345. What the audit found was that enforcement action was seldom taken against couriers for non-compliance. And what's noted is that the lack of penalties to encourage compliance could foster or may have fostered an environment whereby couriers intentionally breach protocols or becoming complacent in fulfilling their obligations. In terms of the audit, can you remember whether that was seen as a significant problem?
It was.
Finally, if we go to 2346, please. This is at 18, please, Mrs. Corea. You note that the audit notes wharfage charges are underpaid in some instances. And that's collected by the BVI Ports Authority, which, and you've set it out in a table, but you note that the practice means that it's got the potential to deprive the authority of a significant amount of revenues. How does the wharfage charges relate to the work of the Customs Department, please?
When you import goods, you have two charges. You have the freight charges and you have the wharfage charges. If you're doing a deposit declaration, you only consider the freight charges are considered in calculating what is actually due. So when the adjustment is completed, you will realize that the wharfage charges that was not incorporated in the deposit declaration is now being considered and factored into the cost. So you will have some times where you would lose money on the wharfage charges and gain on the wharfage charge. But for the most part, because of the level of the cost, it would be that the wharfage difference would be more.
Thank you. Commissioner, I think I've reached a convenient point. There's a few more matters on this report that I can deal with first thing tomorrow morning. Appreciate for Mrs. Corea, it's been a long day. She's kindly agreed that she'll come back at 10 o'clock tomorrow and we'll finish her evidence tomorrow.
Good, thank you, Mr. Rawat. And thank you, Mrs. Corea. So we'll break now and we'll start again at 10 o'clock tomorrow. Thank you very much for your time and responses today. And we'll see you again tomorrow. Again, of course, remotely. Yes? Thank you very much. Anything else, Mr. Rawat?
That's it for today.
Good, thank you very much.